All right. Mr. Kinshala, can you hear and see the court? We can get started.
Your Honor, this is Mr. Sherm. I can see and hear the court.
That works. This is the guardianship and family law matter. If you're here for guardianship or family law, you're in the right courtroom. If you're here for a civil matter like an eviction or something, you got to go over to courtroom, I think it's one. So
if you have a combination of domestic violence protection or
yeah, that's family law, DV, that stuff's all here, Ms. Campbell. So your case is here. If you got basically a eviction, unlawful detainer, or some other type of civil matter, then you're over in courtroom one. Just want to make sure everyone knows that. Today's docket's being conducted via Zoom. That's the county's new video and telephone conferencing system. Courtroom doors open and unlocked. Members of the public can appear in person or on Zoom. Likewise, counsel of record and pro se litigants can appear in person or on Zoom. If you're on Zoom, you need to keep your cameras off and your microphones muted until your case is called. If we have too many people unmuted at once on Zoom, it can create feedback through the system and doesn't make as clear a record. So I did make the announcement that courtroom one, if it's courtroom one, right? For any unlawful detainers or other civil matters, can you make sure if there's any family law or guardianships, they come over here? Perfect. All right, thanks. All right, that's the Zoom announcements. So we do have a few guardianships. I always take those first in case the incapacitated people are here. So the first one is the guardianship of Trevor Gollahar, 20-4, 112-13. Anyone present on the guardianship of Trevor Gollahar? Specifically, Stephen Gollahar? Bryce Mackey was the attorney for Mr. Gollahar earlier. Anyone present? All right, we'll set this aside. I'll call it again at the end. I'll send a letter if no one's here. That sometimes they miss the review dates. All right, the next one is the guardianship of Cheryl Richardson, 21-4, 82-13.
This is Vicki, and I'm here to represent Cheryl.
All right, I did see the report, and I saw you provided a order. Oh, can you state your name for the record, the full name, ma'am?
Yes, Vicki Wertman, W-E-R-T-M-A-N.
And you are the court-appointed guardian, correct?
Yes.
All right. Is anyone else wishing to be heard on the matter? Anyone else present wishing to be heard? And Ms. Workman, did you expect anyone else to appear?
I did not, thank you.
Okay. As indicated, I did see the report. Everything looks good. We do have to, I put in a review date. So you're wanting to do annual reviews for 12 months. And the last review period, it runs from July to July. So I put a review date of October 31st, 2025, since it's a July to July reporting period. So does that work for you?
That's perfect. Thank you so much.
Okay. And sir, you need to mute. Were you here on a case? Whatever the iPhone 6. Are you here on the Workman case? No. You need to keep muted and your camera off, sir. So, all right. I'll sign the order. I did change that review date, or added the review date to Friday, October 31st, 2025. If you need a copy of this order, ma'am, you can get one from the clerk's office. I have signed it.
Thank you so much.
Thanks. All right, the next guardianship is the guardianship of Damian Elledge, 24-4, 160-13. Go ahead and have a seat wherever. You can sit there. That's fine. Can you go ahead and state your name, ma'am?
Ayla Merrifield.
Okay. And you are the proposed guardian?
Yes, Your
Okay.
Honor.
And who are you?
Damien.
Okay. Are you having a fun day? Getting to miss school? So we'll get you back to school here ASAP, okay? We'll get you back to learning. So, is anyone else present on the guardianship of Damian Elledge? Specifically, I think it's Katerina Dubayek. The court visitor is Katerina Dubayek present? Anyone else present on the guardianship of Damian Elledge wishing to be heard? Ma'am, did you expect anyone else to appear?
I didn't, Your Honor.
Okay, I just announced so that we make sure if anyone is here, you know, they had notice. So I saw the court visitor report. The mother unfortunately passed away. I saw that. And there's no father on the birth certificate. I saw the steps that were taken by you and the court visitor to identify potential individuals.
Yes, we did.
And, you know, someone potentially, their whereabouts are unknown, and there is no one listed on the birth certificate.
Yes, Your
so-
Honor.
At this point, everything looks good. Do you have an order?
I have, yes.
Okay, perfect. And I saw that the court visitor interviewed Damian and that he's good having you as the guardian, so. And is this his? Okay, so he turns 18 on August 8th of 31?
Yes, Your Honor.
Okay, so it makes you, what, about 11, 10, 11?
Yep.
You in fourth
11.
grade, fifth grade?
6.
Sixth grade. I lose track of time. You know, my kids are a little older, and I lose track of where, at what age, who was in what. You like in school?
Yeah.
All right. Who's your teacher?
Miss Lamas is my math teacher. Miss Valancourt is my science teacher. And Mrs. Lindgren is my ELA teacher. And Miss Morgan is my social studies teacher. And my Mr. Reed is my art teacher. And Mrs. Gardner is my PE teacher.
That's right. I forgot. As you get older
He's in
and you get out of
junior
the
high, Your Honor.
elementary schools, you get more than one teacher.
Yeah.
So, you know, they don't just have one teacher for the day, but, so do you like recess probably?
Mhm.
And you like math?
Yeah.
Science, all the good stuff. All right. Well, that's good. So you got the date in there for when he turns 18. Looks like do you have everything else filled out? No.
A lot
Yes.
of that, Your Honor, I don't really know the findings or any of that, so there's not really much to his case other than what I have.
Yeah. So what you need to do is you need to kind of go through, what I'm going to ask you to do, if you can do this, I'll
Yeah.
recall the case.
Okay.
If you can just step out and like on each of the questions, there's a box and you can check the box. You filled in the information as far as the guardian and the child, and you got the when the letters expire. I'm not going to require any reviews. I saw the court report. Everything appears in order. It's not like it's for adult guardianships we have to have reviews, but there's no money. He's not a child actor, right? You haven't. You're not starring in any movies and pulling in 6-7 figures. No. Okay. So there's no, you know, money, but if you can just go through and fill this out, check the box that's most appropriate. It's going to mirror the petition, you know, that you filed as far as, you know, your requests, and it'll point you as the guardian, and then the letters of guardianship, you'll need to mark that, and they'll expire when he turns 18. And just go through, and you can go out in the hallway, and if you just sneak back in when you're done, I'll keep an eye out, and then we'll recall the case and I'll sign the order for you.
Okay, thank you, Your Honor.
We'll get you back to school. Thanks. All right. Next guardianship is the guardianship of Shyla Herrera, 24-4-211-13. I think that's yours, Mr. Heaps, correct?
Correct, Your Honor. Good morning.
Good morning, Mr. Heaps. I have reviewed everything. Do you have anything you want to add to I saw the court visitor report. I saw your petition. Anything you want to add?
Nothing in particular, Judge. I just want to introduce my client, Dora Herrera, to the court. She's here this morning with Shyla. And I believe that Ms. McNinch is also online if the court has any questions for her.
Thank you, Mr. Heaps. Ms. McNinch, I did see the court report. You know, you did a thorough investigation. Anything to add to that report or any changes?
No, Your Honor, there's not. Thank you.
Okay. Is anyone else present wishing to be heard on the guardianship of Shyla Herrera, other than the petitioners? Anyone else here wishing to be heard? Mr. Heaps, did you expect anyone else to appear?
We did not, Judge, no.
Okay. The only question I have, everything appears in order. I saw your proposed order. Is the next review is set for 2 years out, but you had a 3-year request, so I didn't know if we wanted to bump that review to the full 3 years as far as the next court hearing.
Yeah, that's always my intent. I know the court sometimes likes to review it the first year and then bump it 3 years after that, but we prefer just going 3 years around. I don't think this is going to be very complicated going forward.
Oftentimes I do the first one a year, especially if they don't have attorneys, but if they're going to keep you, I don't mind doing the 3-year. I know it's a cost, so we try to minimize that as much as possible. So do you want that next review then? Can you get me a 3-year out date on a Friday?
Yes, I can do that. I usually just ask Siri to help me. Is that okay? Or does Your Honor, do you see one there close by? Do you have a date?
No, I don't, because I don't have one 3 years out. My calendar doesn't go out that far.
Hang on just a second.
Or if Miss McNinch can help, maybe some also find one. Yeah, Madam Clerk, if you want to. A Friday in May of, what would that be, 2028, right?
There's Friday, May 5th or Friday, May 12th.
Of 2028?
That is 2028, Your Honor.
Okay. So I'll set it out to Friday, May 5th of 2028, and I'll sign the order.
Very
Like I
good, Judge. Thank you.
Five, 36 month, and I just need to make sure. Oh. All right. Okay, anything else in this matter?
Nothing further, Your Honor. Have a nice weekend.
Thanks.
Thank you, Ms. McNinch.
Thank you.
And is that your only case, Miss McNinch?
Yes, it is, Your Honor. Thank you.
All right, thanks. All right, the next guardianship is actually, we got a couple of states, the state of Belen Noyola, 25-4, 9-13. Oh, that's Mr. McKean's. I think he's just coming in now. Mr. McKean, I was just calling the estate cases. Are you ready?
I will be.
Okay. The estate of Belen Hernandez Noyola, 25-4, 9-13. Okay, is anyone present wishing to be heard on this matter other than Mr. McKean and his client? Anyone else present? Anyone on a WebEx or Zoom, I mean? Zoom's the new platform we use. It used to be WebEx. Specifically, Gracie Ortiz, Johnny Noyola, Rosalina Cruz, Marcia Griffith, Macy Beckford, Francisco Noyola, Abel Noyola, Gabriela Noyola, or Philip Noyola, or anyone else interested in the guardianship of Belen Noyola, not guardianship estate of Belen Noyola. Anyone else present or anyone present? So, Mr. McKean, I saw that you filed for the estate. You did give notice to all the other heirs. I have the affidavit of mailing. It was more than 10 days prior to today's hearing. Have you received, nothing's been filed in the court file as far as objections. Have you or your office or your client received any objections to your client being appointed the PR with non-intervention powers?
No objections. Actually, the truth is, I know these people well. We've been in discussions. There's a house to be sold. So there's been discussions going on, but no, nobody
No
objects
objection.
to
Okay,
this.
I just wanted to make certain. No one's here. I announced if anyone's here for the case. I also specifically called out the heirs. There was a lot of kids.
Big family.
Yes. So, do you have, actually, I have the proposed order.
Yeah, so
Yeah.
but I have one if you need one.
No, I have them here.
Okay.
Here's the order issuing. And if you, do you need these bench copies back?
If you don't want them, I'll take them.
I'll keep the order, but you can have, there's letters in there and a couple other things. Thank you. All right, I will sign the order appointing Jose Noyola as the PR. I will grant non-intervention powers. Actually, it's letters of administration because there was no will. There has been proper notice. It does appear the estate is solvent. And no one appeared to object. I've signed the order. Anything else in the matter?
Not in that case.
Thank you. And then we have one other estate. It's the estate of Edmund, probably going to pronounce it wrong, Prushoff.
Okay,
Edmund Prushoff.
that's it.
All right. This is, and Julia Prushoff, Edmund and Julia Prushoff, cause number 10-13. Is anyone present on, wishing to be heard on this estate? Anyone present? Specifically, there's only two heirs, Holly Clark and Edmund Prushoff. Anyone present on the estates of Edmund and Julia Prushoff, either Holly Clark, or Edmund Prushoff? I mean, that's a junior or a different middle name, but it's one of the kids. No one's answering. Mr. McKean, did you expect anyone else to appear?
No, it's not objected to.
Have you received any objections or any notice from either of the other individuals indicating they're objecting to the non-intervention powers?
None.
Okay. No one's here. They were given the proper notice. The petitioner is the other child. And so this is kind of one of those things where there's a will for the mom, but not for the dad. The dad predeceased. So technically, I guess they're kind of letters of administration for the dad's estate. But your argument is that everything passed from the dad to the mom when he died 20 some years ago, because it was all community property. And then the mom left a will. And though there's letters of testamentary for that, but basically the PR under the mom's will is going to, they're going to do both estates. So,
Correct.
All right. I will find the estate solvent. I saw the materials in there, and I'll grant the non-intervention powers. The petitioner is a resident of Washington. They were named in the will for the mom. And like I said, it does appear the parties were married for a long period of time before dad died, and mom never remarried, or at least wasn't remarried at the time of her death. All right. I've signed the order. Anything else in this matter?
That is it. Thank you.
You can have these bench copies if you want some extra copies to conform for filling out. Thank you. All right, that is all of the guardianships and estates that have been called. We'll wait when the one comes back in. I need to call one case out of order. It is the Nixon matter, 24-473-13. It's Mr. Gilreath and Mr. McGee. Are you guys present?
Present, Your Honor. Thank you.
Mr. McGee? Mr. McGee present?
I see he's on the WebEx.
Hey, Mr. McGee? So, Mr. McGee, are you there? Well, I can recall it.
Hi, I'm sorry. I was my I'm not my unmute button wasn't popping up and working. I'm sorry about that.
That's fine.
I can get this thing figured out here. Okay.
It's the matter. I need to call it first because there's an interpreter need, and it's a Creole interpreter. And so when that request was put in, the interpreter coordinator couldn't secure an interpreter until February 7th, next week. So this matter will have to be stricken or not stricken, but set over to next week. I do, however, need to ask both counsel. This week is a big docket. Next week is a big docket. If this matter is, if it's going to take more than 10 minutes aside with the interpreter, you may want a special set. I don't want to have to keep on, rescheduling. I know there's, costs associated with that. So
Sure.
now it doesn't appear that there's major disagreements on the parenting plan as far as who's going to have custody and whatnot, but there's minor disagreements over all the minor provisions of the parenting plan. Plus there's disagreements on child support and some bigger disagreements on financials. Is counsel with interpreters going to be able to do everything in 10 minutes aside, or do you want to contact the court administrator and get a special set so you have a little time, don't have to, run into any problems? If you can do it in 10 minutes aside, I don't have a problem. But we can't take an hour on the Friday docket when we got 20 plus matters set over next week.
Your
I
Honor,
can,
Your Honor, I'm okay with a special set. There's also restraining order issues in this too, so we got like the full buffet, if you will.
Mr. Gilreath, do you want to do a special set? I know there's a lot of issues, but what do you want to do?
I personally don't. My last experience with a special set I tried in October is now going to be heard in February. The parents are in need of a parenting plan. Could we stipulate to handle the finances of the restraining order separately on special set and address the parenting plan just in one of the next week's hearings?
Mr. McGee, work for you. We'll deal with the parenting, and then you guys can work on a special set for everything else.
Well, Your Honor, my client is starving. I mean, because he won't pay support. So we're gonna,
You can have minutes.
yeah.
Is that good enough? And that's with interpreting. So you got probably 5 minutes because it's going to go.
That's fine with me, Your Honor. Thank you.
Yeah,
I'm going to hold you guys to the 10 minutes because.
Yeah, I really am comfortable with a special set. I'm sorry. If it was an interpreter case, I think I could probably economize. I'm sorry. I don't mean to be difficult.
Like I said, set over to next week. You got 10 minutes.
Wait.
Thank you, Your Honor.
No, I was voting for the special set, but if the court's ruled that we're just going to do everything.
Well, you said you
next
didn't.
Week.
Well, are we going to just with the parenting plan next week and get a special set for everything else?
Well, the problem is, Your Honor, my client has no money.
Okay, so 10 minutes. You got 10 minutes next week then to get whatever you guys want out in front of me. I'll review the stuff and you may not have, I mean, I'll review everything. So I'll just be ready to rule whether you guys argue about it or not. I'll give you this and that's what we'll do.
Yeah. Are we sure the interpreter is available on the 7th?
It's available on the 7th.
Okay. Well, yeah, Your Honor, I appreciate your sensitivity to the matter, and we'll get what we can get done on the 7th.
All right.
I appreciate the sensitivity to it. Okay, thank you.
Those other people still aren't in. All right. At this point, I always ask, are there any agreed continuances? Fully agreed matters. We'll take you first so you don't have to wait till noon. If you've got agreement, you get moved to the front of the line. So.
Your Honor, on the Harrington matter, there's only a handful of very small differences that I have with the proposed order from Mr. McGee.
Okay, yep, and I'll get to those. I do those usually after all fully agreed matters.
Okay.
So agreed continuances, agreed matters. Anyone have agreed continuances, agreed matters? It's a big docket, but that's fine. So, all right, I'm not hearing anything. Let's go ahead and recall that guardianship, the guardianship of Damian Elledge. Yep. Came in at the right moment. Oh, thank you. All right. All right, recall the guardianship of Damian Elledge. So, ma'am, you went through and filled.
Yes, Your Honor.
Okay, perfect. Everything does, the notices, yeah, you just have to read, you just read through and you mark the stuff, and it looks like you did a good job. So, partnership is approved. I will sign this and we'll get Mr. Elledge back to school.
Thank you, Your Honor.
So, 1/31/2025. If you need a copy of this, did you bring copies?
I didn't, Your Honor.
Okay. Did you bring letters of guardianship?
Uh,
Letters? Because that's actually the document. It's like a 1 or 2 page document you take to the clerk's office. This directs the clerk to issue the letters. That's what gives you the power, like the school or the doctors, if they wonder, why are you bringing him in?
This is something I get from the clerks?
No,
Or-
you'll where you downloaded these
Yes.
forms, you'll go on there and you'll find letters of guardianship, and then you bring those in. There's also an oath of guardian you'll need to fill out, and so you probably have to come back, but you don't have to come back to court. You can
Okay.
just come and whenever is convenient from 8
Clerk's
to
office.
4:30,
Okay.
except for 12 to noon when they're closed, and you can go to the clerk's office, bring in the oath of guardian, and then print out the letters of guardianship. They will charge you yeah,
Page.
it's 50 cents a page, so they charge, for a couple of those things. But, and then you get those, and that's what gives you the authority to act if anyone questions. Like the school or a doctor,
Okay.
things like that. So,
All right.
All right,
Thank
thanks,
you,
but I
Your
signed
Honor.
the order, so. Have a good one. Stay in school. Sounds like it's not a problem. He likes school, so.
Yeah.
All right. All right. Nobody had any agreed continuances. So I'm going to take a couple. We got some presentations. I'm going to take those, and we've got a trial setting or two. So, all right. Let's take the Cutlip and Ortega matter, 24/3/129/13. All right, Mr. McGee, that's your case.
Yes, good morning, Your Honor. I think we have,
And represent Kevin Ortega, correct?
yes, I do, Your Honor.
Okay, is Tiffany Cutlip present? Tiffany Cutlip, *6 to unmute on the phone, unmute button on the app or computer.
I'm here, sir.
Okay, can you state your name?
Tiffany Cutlip?
Okay, thank you. And Mr. McGee, is your client present?
Well, let me see here. We got, hello, Mr. Ortega. I'm looking here on the, I don't see his tile, but we have some guests. Maybe Mr. Ortega could unmute if he's here and let us know. Hello. Well, we gave him notice of the, to be here, but
You're his attorney.
yeah, I'm his attorney. Yeah,
Oh.
he has a bunch of kids and he works, so.
That's fine. That's
Yeah.
fine. So you're his attorney. Ms. Cutlip, I'm going to swear you in. If you could raise your right hand.
Okay.
Do you solemnly swear or affirm the testimony you're about to give will be truthful under penalty of perjury of the laws of the state of Washington?
Yes.
All right. You can supply the jurisdictional testimony that's necessary for the documents because you do have minor children. But before we get there, I just want to make sure I have documents, ma'am, that were prepared by Mr. McGee, and they do appear to have your signature on them. Are you in agreement with the documents?
Yes, sir.
Okay, and you had a chance to review them before you signed them, and
Yeah, yes, I did.
okay, and you want the court to enter them today?
Yes, sir.
Okay, then, ma'am, I'm just going to ask you a few quick questions, jurisdictional questions, because there's kids. Can you state your full name for the record?
Tiffany Marie Cutlip,
And to whom are you married?
Kevin Ortega.
And you guys were married, you were married on April 6th, oh no. Oh, where's the
January 30th, sir, 2014.
2014? Oh, all right. And you separated on what date?
I believe it was April 16th is when we filed.
Okay. And is your marriage irretrievably broken?
Yes, sir.
Have you and Mr. Ortega already divided all of your property and debts?
Yes, sir.
Is that division fair and equitable?
Yes.
Did anyone want any protection or restraining orders?
No.
And you're not now pregnant?
No.
And you have 4 children that are dependent upon you, born of the marriage that are dependent upon you and Mr. Ortega?
Yes.
And you and Mr. Ortega have arrived at an agreed parenting plan?
Yes.
This parenting plan in the kid's best interest?
Yes.
Does parenting plan allow for both parents to maintain an appropriate parent-child relationship?
Yes.
And you and Mr. Ortega have agreed on a child support order?
Yes.
And does this child support order allow sufficient funds in both households for the children?
Yes.
And you're not currently on TANF, cash payments from the state?
Not from Washington, no.
Okay. And and to the best of your knowledge, Mr. Ortega isn't on TANF, cash payments from the state?
To the best of my knowledge, yes.
Okay. And did anyone request a name change?
No.
Okay. Mr. McGee, did you have any other questions?
No, I appreciate Ms. Cutlip being here today so that we could get this matter resolved. I appreciate her work and showing up at mediation and working with Mr. Hatch to get this matter resolved.
And Mr. McGee, on behalf of your client, you've signed for him the documents?
Yes, I believe so. Thanks.
And you're in agreement with having them entered?
Yes, absolutely.
I'll adopt the party's parenting plan, find it to be in the kid's best interest, and sign the same. I will sign the child support order and worksheets, find the party's incomes to be as delineated in the worksheets. I'll sign the findings and conclusions. And then the final divorce order. The parties are now divorced. All right. Anything else from you, Mr. McGee, on this matter?
No, Your Honor. Thank you for the vote, allocating the time for it this morning.
Okay. Anything else from you, Ms. Cutlip?
No, sir. Thank you.
Okay, thanks. Your case is done, Ms. Cutlip. You're free to stay and observe, or you can sign off if you have better things to do.
Okay, thank you. Have a good day.
Thanks. All right, we've got the Nelson matter, 24-3-425-13. It's on for presentation. That's Mr. Hugo and Mr. McGee. And so, like last week, the parties were before the court last week for presentation. There was a little bit of a dispute. Mr. McGee had provided the transcript of the hearing where I ruled. I set it over a week because that transcript was prepared. It was provided really late, and I didn't have a chance to review it. So I sent it over. I did review the transcript and my notes. I would point out that the temporary orders provided by each side were very similar. You both mostly agreed on the big stuff. The only bigger item in dispute was the standard financial restraints, which I did include. Mr. Huberdeau had requested those in the motion, and he did indicate in his argument that he didn't think there was much of a disagreement about that. And Mr. McGee didn't object to the standard financial restraints, and they are mutual. They keep both parties from disposing of assets, changing insurances, things like that. So I did include that. They were requested, and the court typically includes that. I did make a couple of tweaks. Both of you had, there's just a couple little things that were left out. I basically used Mr. Huberdeau's order. I made a tweak at paragraph 5, provide support. I just added to make it clear the December payment is for a half month only. That 12/20/2024 was for a half month payment. And just to make it clear that the December payment wasn't for the whole month. So it was $500 for December and then $500 for $1,000 for January and February, but paid in 2 equal installments. What I did do on the attorney's fees and costs, it wasn't really reserved. The court, I made a comment and I had in my notes that it's denied at this time. Maintenance equalizes the party's income based on the information available, which is what I did. The parties' incomes were equalized. So it's denied at this time. I know there was statements made about, 31,000 the wife took and 51,000 the husband has. And depending on how that all ends up working out, there may be something that comes before me, because the other thing that I added that was neither of you put in, and I did order it, I said either party may review this matter, may review the maintenance order anytime after February 15th, 2025 with the filing of updated financial information. I did not have full financial information. When I ruled, we did kind of close enough for horseshoes and hand grenades. I think I used that phrase in the court's ruling. So that's what I did. Basically, it's $1,000 a month, and I added a few tweaks to just fully encompass the court's order. And I have signed that order, and it is filed.
Thank you.
All right. We've got a couple other presentations. We got the Harrington matter, 24-3, 434-13. That's Mr. Kinshala and Mr. McGee.
Good morning, Your Honor.
Morning, Mr. Kinshala. Mr. McGee, you're present.
Yes, just unmuted there for you. Thank you.
Perfect. So Mr. McGee filed some orders. There weren't any alternate orders filed by Mr. Kinshala, nor exceptions that were filed. Now, Mr. Kinshala, I understand if you have a couple minor exceptions.
Very minor, Your Honor.
That's not a problem. I always like it if you can at least file just a short declaration or exception that just...
There's nothing that I have that would require significant argument, Your Honor. I believe that Mr. McGee's order is consistent with the court's ruling. There are some other provisions that weren't addressed, but we are fine with those. The only things that I wanted to discuss are the exchange provision, which the court didn't address in the ruling, and the exchange time, which the court did address at Sunday at 6 p.m., but my client has a request for it to move to Monday at 6 p.m. because she has some occasional Sundays where she works until 6 in Everett. And so that would be difficult for her. She had to make arrangements with Mr. Harrington over our family wizard. So that would be a request from her. The exchange location that is in the order presented is at Mr. Harrington's mother's address, or his parents' address, where we now understand that he's staying, which was the source of the confusion, disagreement last week. And that is a potential grounds for conflict if that's where they're exchanging. So she's requested a neutral site. Just a moment, let me get that address. That's about 5 minutes from both his current residence and her current residence, of the Rite Aid on 112 Canyon Road in Tacoma.
Okay. Everything else in Mr. McGee's parenting plan, and I think it was just parenting plan, right? That's the only one. There's not a
The
template.
only other clarification is she did want to know whether the court was requiring that the parties themselves be present for exchanges. There's been allegations from Mr. Harrington that she hasn't been involved.
For a second, hold on, let me stop you there. What the court generally does is, I don't require like the parents themselves to physically take the kids. It's reasonableness. You know, I don't care if they send somebody that is known to the child and not a sex offender. You know, I mean, if they want to send grandma or grandpa or brother or sister, you know, that's an aunt and uncle, or a best friend that's the family's known for 20 years and the kids are really good with, I don't really care. I don't send a stranger or a sex offender or something like that. So, you know, I don't require the parent themselves, but don't send someone that's not known, you know.
But thank you, Your Honor.
Okay, perfect. Mr. McGee, as far as the switching from Sunday to Monday, it's a 50-50 plan. Does your client have an objection to changing on to exchange on Monday nights?
Well, Your Honor, I think for the benefit of the child, it's usually better to do, you know, a Friday or a Sunday. You know, here's what I would ask the court do. Let's just keep it as it is, and if there's some kind of better explanation that isn't kind of at the last minute, then I can run it by Mr. Harrington, who I think is really reasonable.
Okay.
And then we can come back if there's a problem. I mean,
Okay. Are you proposing Friday?
Well, I've
that-
always, you know, personally, we have to ask Mr. Harrington, but I've always thought Friday or Sunday was the best way to go.
So
Mr. Harrington's here. We could ask him if he absolutely wants the court's initial ruling of Sunday, or if he's okay with a Friday. You know, he's a pretty good dad, and I think he would know what his son would want to do. I've always liked Friday because, you know, the kid's excited to see dad, and they go have a fun weekend before.
Mr. Harrington,
Yes, sir.
Monday or Friday or some other day?
I prefer to keep it on Sunday. Monday would work. I could make Monday work, but
Okay.
I prefer Sunday, but I can make Mondays work.
Okay. As far as the pickup location, generally the court cuts it in the middle, meaning the picking up parent, I think I put that in that interim order, you know, you go to each other's homes and picking up parent goes and picks them up. You can also meet in the middle or some other location. Mr. McGee, I'm not going to make mom pick up and drop off at dad's house. I don't do that unless the parties agree. So do you want to meet at a neutral location? Is that Canyon Road, Rite Aid work for everyone? I don't really care. I just want it to be something that works.
I think we got a thumbs up from Mr. Harrington on the Rite Aid there. I mean, if he feels safe with that, I feel safe. You know, the reason I proposed the parents' house is that it's a stable, fixed place with Ms. Harrington switching jobs a lot, and
we're
you know, it was.
I ruled.
Okay.
I just wanted to know the little detail. I did not talk about, you know, I generally make it, you know, at each parent's house, but all right. So I'm going to change the location. The children will be picked up and dropped off at the Rite Aid at 112 Canyon Road. Is that in Puyallup?
I'm looking up. I'm looking it up.
Yeah, I don't remember if it was Puyallup or Tacoma technically.
It's Puyallup. I live
Puyallup?
there.
Okay. I went to school down at PLU. I know Canyon Road, but I know it also runs,
Yeah.
I mean, Puyallup runs into Tacoma there.
Your Honor, I think the official address, at least is 11220 Canyon Road East, Puyallup. That's what I'm,
Put the Rite Aid on Canyon Road.
Canyon
Yeah.
Road East. Canyon's a weird street. There might be,
Okay, don't come in on contempt about the pickup location, please.
yeah,
As far as the exchange time, what I will do, or the exchange is, if mom has a problem with Sunday nights and dad says he prefers Sunday but can make Monday work, I'm going to make it Monday at 6. I will, just to appease everyone and make sure it was kind of last minute and there was no except. That's one advantage of at least filing an exception. Then they can see what the issue is. I will put this matter can be revisited. This matter of day of exchange can be revisited by motion of either party. But unless you got a real good reason, you know.
And
Your Honor,
father has set up, oh, sorry, excuse me.
Your Honor, could we also maybe come back on the location? The court's aware I lived over there in that mess for 28 years, and some of these Rite Aids are really kind of crime hot spots. I mean, it's a way different life over there than it is here.
Okay, that's fine. I'm not going to put that in. Obviously, it's a temporary order.
Okay.
The parties, if there's a problem, if you can't work out where to meet, then I guess you can file a motion.
Okay.
I'm not going to revisit anything else. But if there's actually a reason, if somebody gets mugged or accosted there, then I guess, and there's a dispute, we'll go from there. So I've signed the parenting plan. I did make those changes. The Rite Aid is the exchange location in Puyallup on Canyon Road, and I changed it to Mondays at 6. I added the language about the date can be revisited by the parties by motion. Hopefully, it's not going to cost,
Yeah.
You
We'll
guys-
see how it goes, Your Honor. I appreciate the rulings. I just, it's just having lived there, I have some of my own, experiences that form the court
attorneys
with.
involved, Your Honor, and with our family wizard having been set up, I think we can work out any necessary changes without
Perfect.
filing motions.
All right.
Is
All
that,
right. So then we have got, let's take the Atkinson and McCanna matter, 18-392-1. Okay, do we have Mr. Ziegler and Mr. Huberto?
Your Honor, I'm here in just a second. Oh, there we go. My computer froze. I'm here.
Okay, and where's Mr. Ziegler?
He's on medical leave for over 30 days. I did contact his attorney's office and the clerk's office early this week to let him know, but I will be representing myself today.
Okay, you don't have a different attorney or someone
No,
else from
he's
his
a private
office?
practice and short of notice, so
Okay.
I understand.
Okay, so
Your Honor, I might be able to help curtail this a little bit. You aren't aware because nothing's been filed, but the kids were returned last Friday. So my client has it, which is why he's not present in court today. I got a phone message yesterday afternoon from Mr. Ziegler's. I think it was his assistant, same one as last time, that just said he's out for an indefinite period of time. I didn't know that she was going to be transferring pro se, but just knew he was out. So I told my client not to show up given those circumstances.
Okay, so kids are returned, parenting plan's being followed right now?
Mm-hmm.
All right, perfect. That's basically what the review was set up for. Is there anything else from you, Mr. Hubert? I don't think we actually have a contempt order entered because, or was there one?
I thought you had signed one, and then I had asked for the review hearing because of the kids, and then I think you signed one.
That's right, I did sign one, and you guys are working, I think I put the language in about makeup would be.
Well, yeah, and with that in mind, Your Honor, I mean, obviously he missed Christmas in 3 months, but I think what's best for the kids, my client agrees, just continuing the schedule as it's supposed to be without having to address makeup time. Obviously, the concept is if visitation is going to continue to be, kids will continue to be passed back and forth, which I think I'm assuming mom intends to do that since the kids got returned last Friday.
Okay.
And if she is, then my client's okay just moving on.
Okay, perfect. Anything from you, ma'am?
I do have a question. I don't need to read from that. Is the Wizard app that I hear other cases have, is that a court direct? Like you can see the messages? Is there anything that, because it's hard to communicate day by day or weeks, months, everything with Mr. McCanna completely, even asking him like, how are the kids doing? I don't want to talk to you, things like that. I want it monitored because, you know, you swear on their oath and everything that comes out of it is lies. So I just want it documented, like the text they submitted and things like that. I want it documented so the court can see who is not doing, you know, what they're supposed to be.
So it's a parenting app. It has
Okay.
multiple functions. There's calendars. There's ways for the parties to communicate with each other and whatnot. It's really not, that's not before the court right now. Now, if the parties agree, if you and Mr. McCanna both agree to get it, there is a cost to it. It's an annual subscription, I think, of $100. There's also other, maybe it's less, and there's other apps that don't cost, and there's a number of things, but it's really not before the court today as far as it's not part of contempt. I didn't order that. I have ordered that in the past. That's usually when there's disputes over communication and things like that. So that's not, but if you guys talk and your attorney, when he gets back, if he and Mr. Huberto want to talk about some of that stuff. So anything else from you? As far as for today, it was on for a review. You know, you were in contempt, but the kids have been returned. If you're going to continue to, you know, do the parenting plan and make sure the kids go back and forth and, you know, at least until, you know, if it's going to get changed, then there's got to be, you know, has to be petitions, all that kind of stuff. But as long as that's followed, then is there any need for further reviews, Mr. Huberto?
You know, I saw mom nodding her head that she's going to follow the plan. So if that's the case, and I don't think so, I'm assuming that's correct. We're going to follow the plan. If Your Honor could inquire with her, I suppose, and that'd make me feel more comfortable if I heard her say it, I guess.
Follow the plan?
Yes.
Perfect.
Then no more need for reviews, Your Honor.
And if kids don't want to go, you got to treat it like school, you know, take their phone away. No, you know, they can read War and Peace. And
Yeah, and I do want to address the court over, like, I never, intentionally violated the orders or anything like that. I put my arms around the kids, push them out the door. There was never a snowstorm. Like,
I know.
I've done everything in my power to punish the kids. And the only reason Adriana, my 14-year-old, grabbed the phone to call 911 is because it's emergency. That's the only reason she had her cell phone at that particular time. And she was told by her counselor, by her therapist, and it's nothing, it's, if the court would just talk to the kids, they would understand why they don't want to go back. I'm going to uphold everything I can to
just make sure you follow the plan. There's a process. I can't just talk to the kids.
Yes, I understand that.
There's, you have an attorney, talk to him about the process. So, all right. That's it then. And no more reviews right now. Follow the plan, and we'll see if anybody, whatever gets filed, we'll deal with as they come.
Okay.
All right. Thanks.
Thank you.
All right. I'm going to take, let's see, do we have, did Mr. McKean run somewhere? Miss Iverson?
I'm here, Your Honor.
Can you see if you can get a hold of Mr. McKean? I don't know if he had the two cases and he left. I don't know if he's in a different courtroom because you guys have that other case.
Correct.
So you can get a hold of him and see if you can get him back into the courtroom. We can take care of that one. All right. Let's see. I was trying to get some of these other ones. Let's do the Queen and Lugo matter, 20-3, 86-13. Ma'am, can you state your name for the record?
Victoria Queen.
Okay, thank you. I have it in my notes, Queen. The original
I appreciate
name on
that.
there. I'll try to remember. I try to. Mr. Curdo, you're here to represent Mr. Lugo.
I am, Your Honor, and I can probably start off and save everybody some time on this too. I think I got recently read the response of Ms. Queen. I think there might have been some misunderstanding. Her and I actually had a pleasant conversation on the phone after our last hearing. Your Honor had talked about potentially waiving mediation, which is part of what the motion was. So obviously we filed this because we have to have something in writing from the court directing what we're going to do on mediation. There's no negative intent towards Ms. Queen. Like I said, she was easy enough to deal with on the phone, and she was open to mediation, just couldn't afford it. So I think that's the parameters. It's however, if Your Honor would like to waive mediation to allow us just to set a trial date, there are limited issues in this case. Or if you would want to address maybe my client advancing the fees for the mediation or not, however Your Honor prefers to handle that. I think that's the only issue.
Yeah, I saw the materials from both sides. So ma'am, you're fine going to mediation at the Hatches?
I don't know who the Hatches are, but
They're family law attorneys that are in Spokane. There's James Hatch and his daughter Jenna Hatch, a lot of mediations. They're family law attorneys, and they do them by Zoom or in person. I think you can do them in person. They do a lot of them by Zoom. They're fairly successful at getting the parties to reach agreements. We have limited mediators in here, and so they're just ones that a lot of the different attorneys use. They're not tied in with any of the attorneys. They're independent attorneys themselves. So Mr. Huberdeau has requested to use the Hatches. If you're fine with that, which I kind of took from your materials, you probably are, you just don't have the funds. They charge, it's like a couple $100 an hour, and it's a few $100 for each side. Because there's a half day minimum, 2 or 3 hours. So it ends up being, a few $100 for each side to pay. Typically it's split, but I wanted to find out, are you good with using them, but it's just the money, you can't afford it right now?
I'd prefer to do an informal trial, but if we have to drag this out even farther, I mean, it's 5 years. So
No, I understand.
what's another 3 waiting for something
Well,
to happen?
mediation is pretty quick. And like I said, they do it for Zoom too. So it can get scheduled within.
I don't have Zoom. I don't know
Okay.
Zoom, so.
You can go in person too, I think, right, Mr. Huberdeau?
You can, but they're out of Spokane, so that would require her to travel to Spokane, of course, which probably be cheaper for her to do the Zoom on her phone. Or...
Are you able to? Here's the deal. There's a local rule for mandatory mediation.
But it wasn't in there when we filed.
Yes, it was. It was in a different way. What it said when you filed was that you had to go to mediation before you could go to trial. It didn't require it before trial setting. So what that was doing was basically clogging up the dockets, because all the attorneys would file a notice of appearance in their petition, and they'd file a request for a trial setting because they knew it was going to get set out of a year plus. And then the cases would settle, but there were all these trial settings that would ultimately settle. So we changed the local rule to require, before you could request trial, you had to go to mediation, because most of the time they'd settle. And then if it actually didn't, then now trial dates you can get within a couple months, a few months, depending if it's only one day. If you want 5 or 6, 7 days of trial, it takes longer. But if it's one day, it's usually only a few months out. So it was there. It was just in a little different format. It can be waived for good cause. That's usually DV or things like that. In this case, just the history of the case, and it's 5 years old, I would prefer not to waive it. You guys would be amazed. I'm always amazed at what actually settles, and you may be able to settle at mediation and not have to have a trial. Whether it's an informal trial, that'd be something that you and Mr. Huberdeau would have to talk about. And if it's agreement, then it can be done. If it's not agreement, then you'd have to request it, and the court would have to rule, and whether I would allow that over the objection. It's usually, I haven't looked at it. We've done one of them one time. They're usually with pro se's, but I don't know what the criteria are if there's a disagreement over having it or not. But if you're willing to go to the mediation, Mr. Huberdeau, your client's willing to advance the fees, and it could get either addressed in mediation or at trial?
I mean, he's not eager to do so, no, but it'd be cheaper than a trial, yes.
So what I'd be inclined to do, ma'am, is order that you guys go to mediation. order that Mr. Huberdeau's client advance the fees. That takes care of the cost issue. If you reach an agreement that includes, what's going to happen with the fees, I'm going to order that he pay it and reserve final allocation. You even kind of mentioned that in your response, that it could get, so that's what I'd be inclined to do. And if he's going to pay for it, then that's what I'll order.
Okay.
And you guys can go to mediation at the Hatches. You can either download Zoom or go to a friend's house.
Well, I drive back and forth from Montana and Illinois, so Spokane is closer than Moses
Well, sure.
Lake.
So
It'll
you can
keep
go
me out
there.
of Grant County.
All right. What I will do, I will sign the order for mediation. I will order as granted. Parties shall attend mediation with Hatch Law Firm, Jenna or James, one of the two of them. And mediation shall be, you can get a hold. Can it get scheduled by March 31st?
Yeah, I don't, if it's okay with Ms. Queen, sounds like her schedule is fairly free. If I could just pick a date that I'm open on, I'll contact Mr. Hatch's office, get dates, and then I'll send her a letter with that actual date. Does that work, Ms. Queen?
That works.
Okay.
It'll probably be in March, I suspect. Yes, Your Honor. It's as far as the dates that go.
All right. I'm going to strike through the second paragraph about not complying. Because you're going to comply, you'll go to the mediation. I'll put that payment to be advanced by husband, final allocation reserved. Okay, so I just said the response motion to waive meet to the party. It says the party shall attend mediation with the Hatch Law Firm. Mediation will be scheduled no later than March 31st, 2025, and parties or payment to be advanced by the husband, final allocation reserved. And I struck through the last paragraph about not appearing. Make sure you go. If you don't, parties are ordered to attend. All right. I signed this order. Hopefully you'll reach an agreement. If you don't reach an agreement, then it can be noted for trial.
Yep. And Ms. Queen, I still have that Moses Lake address you said you prefer. So I will get probably a letter out to you first of next week with the actual date. If you have questions, give me a call.
All right, thank you.
Okay, thanks. And do you have a phone?
Yes.
You can appear remotely via your phone. You're more than welcome to come here all the time. Great to have you here. I don't care. It's great. I like to see the people in the courtroom. But if you're coming from Montana, you can download the app and appear on your video on there, or you can just phone in with the instructions. They're on the website, and you can your phone number up there. And then you can mute and unmute when I say *6, and you probably heard that. You've been in court enough. So you can do that. You're more than welcome to be here. Love to see your face. I'm not saying don't come. I just want to let you know if it is a hardship, by all means, you can do that. You can also use your phone to access the Zoom, I'm sure, for going to Spokane, but go there in person if you want.
And hopefully we don't have any other hearings that she has to come to anyways.
Finger crossed.
Thanks.
Thank you.
All right. Mr. McKean,
Yes.
Let's take the, I got to get it here. It's the grandparent one that is.
Galeana.
Yes, I got to find it. Where'd it go? Here it is. The Galeana and Espita. Espatia, 24-3-159-13.
I have to admit that I thought that this would be preliminarily decided by the court, not an open court. And so I did not come prepared to argue today.
And so I don't have to, this is the grandparent statute. And so there's a hearing on the merits, so to speak, which can be had. This is like a threshold hearing. And so Miss Iverson has requested attorney's fees on behalf of her client. Now, she didn't request the attorney's fee. The clients didn't come in and ask for attorney's fees in advance, which they're allowed to do and could do. And your clients would have to pay attorney's fees for them to go seek counsel. Or your client's case just gets dismissed because it's mandatory under the statute that your clients pay for the parents' attorney's fees if they ask for it in advance before they do anything. They did it a little different. They went and hired an attorney who then came in under the statute and says she wants attorney's fees for bad faith because this action was brought in bad faith. And so what I can do is I can set this over for that issue so that you can respond to it because you saw their request. And under the
Can't say that I
statute,
did.
You didn't?
No.
Okay, it's in the response, so I didn't know. So I can set this over on that issue. If you
What I
want,
saw,
because basically, Mr. McKean, I'm going to deny your client's request as far as the case is going to end. There's really not a basis. They haven't had contact with the kids. They admit in their materials for more than 2 years, and there's a current restraining order. Now, they referenced it in their materials, and the mom supplied a copy of it, and it was renewed. But there's not a basis to, mom has under the statute, it's going to get denied. The whole issue is going to be attorney's fees in bad faith if this was brought in bad faith. So if you want to continue it to argue that issue, you can, but as a threshold, I would find that they didn't meet the statutory criteria. They haven't seen the kid in 2 years, and the mom has a valid reason. And the statute says, if there's a valid reason, arguably they could have just said, give me attorney's fees first, and I would have ordered $1,500 in attorney's fees before the case even goes forward for them to go in and before, file their objection, because that's in the statute. They get the attorney's fees to try to contest it, and it has to be advanced by your client, unless they're Bill Gates, and I can find that they don't need the attorney's fees. But so what do you want to do? Do you want to contest the bad faith? And I can set it over for a hearing on the bad faith, but my court review of the file is I'm going to deny it. They didn't make enough of a showing.
You're going to deny what?
They don't make their case.
You're going to deny the petition.
Deny the petition.
Okay.
And the issue of attorney's fees, if you want to address that on whether attorney's fees should be ordered, I can set that over for a hearing and you can supply a response. Or Ms. Iverson, what is the request for attorney's fees? So Mr. McKean can make relate to his clients. And if there's no further hearing, what are your fees that they're requesting be paid?
Your Honor, we're requesting $1,500 in attorney's fees.
$1,500?
Okay.
Yes.
And I would, for that amount, there'd have to be an affidavit. I mean, that would support the time that went there. So you need to file that. And then I can set this over like 3 or 4 weeks to give you a chance to look at everything, talk to Ms. Iverson and your clients. And if you guys arrive at an agreement, whether it's no attorney's fees and it's just dismissed, or some attorney's fees, or you want to argue it, then I'll hear. And I'm not finding bad faith right now. I'm finding that your clients didn't statutory. It's a tough hill to get over. And especially with the restraining order, they haven't seen the kids for 2 years. But I'm not making a ruling on bad faith. So I'll let you guys discuss that, and you want me to set it over like 4 weeks to give you adequate time?
Please, I'm a little blindsided. What I saw was a copy of the restraining order that was sent to my office, and that's what I saw. I didn't see any more.
Okay, yeah, they put in a response to the petition, which they're allowed to do. They get kind of two cracks at the cookie, so to speak. They can, at the beginning, if the court denies it like I'm doing, then that just ends it. Or even if I allowed it to go forward, then there'd be a whole trial on it, and they could dispute it there as well. But
There
I'm
are some,
finding
there are
yeah.
some facts to be brought forward on a
bad
claim
faith.
of bad faith.
Sure.
Yes, we spent a lot of time trying to execute service.
Sure,
It was
not a problem.
it was-
So
they
like
were
I said,
hiding.
I'm not ruling on that. When do we want to, so Miss Iverson, Mr. McKean, I'm thinking like maybe either the very end of February 28th or March 7th, so that you guys, and then Miss Iverson, you'll need to get an affidavit in. You guys can negotiate and you can see what you want to do. I will, like I said, I'm ruling that I'm denying the petition, and the issue of the bad faith on the filing is reserved over to 28th or 7th.
February 28th is fine.
28th work for you, or do you need the 7th, Mr. McKean?
28th works.
28th? Okay. Set over to the 28th for that issue. I will fill out, and to be honest, probably the best thing is, yeah, I'll either fill out the order after review of the petition, or I'll just wait till the 28th and enter that as well. But all right.
Okay.
Okay, that's it in that case.
Thank you, Your Honor.
Thanks. Okay. Okay, the Magallanes and Sanchez matter, 24-3-239-13. Do we have, is Miss Magallanes present?
Yes, Your Honor.
Okay, can you state your name?
Leticia Magallanes.
Okay, thank you. And you're the mother, correct?
Yes.
Okay, and then Mr. Sherm, you're here on behalf of Mr. Sanchez
Correct, Your Honor. My client's appearing via Zoom.
as well? Okay, perfect. So this is on for moms. It's on for both of your guys's, the order appointing a GAL. Judge Nodell ordered / you guys agreed. I'm not sure exactly what happened in that hearing specifically, but I know the ultimate outcome and effect was there's going to be a GAL. You guys both agreed to that, and or Judge Nodell ordered it or whatnot. The issue was kind of payment and who was going to pay and how that was going to get arranged. It's going to be Miss Lotstein. I saw that. And the only issue is the mom's requested a finding of indigency, or actually she says there's already been one signed by Judge Hill 6 months ago, and requesting that her portion of the GAL fees be paid by the county. So that's kind of the only issue, right?
That's correct, Your Honor. I think the form of the GAO orders agreed to really is just payment of cost and how those costs are being to be designated.
Okay, Ms. Magallanes, you agree, just the form of the order is good. It's your portion and his portion and who's going to pay what.
Are you referring to what I proposed?
Yeah, I think Mr. Sherm just said that you agreed to the form of the order, not on the payment portion. That's the argument right now. But
yes.
Agree to Ms. Lotstein and all that and everything else. Perfect.
Yes.
I'll hear briefly from you, Ms. Magallanes. I have reviewed the materials. I'll hear from you and then I'll hear from Mr. Sherm, and I might have a question and then I'll rule. Go ahead.
Okay. So on 10/25 hearing, Judge Nodell ordered the guardian ad litem, the appointment of guardian ad litem, because he was under the impression that, you know, it would take a long time for a trial to happen in this case, and did not want the temporary parenting plan to be a final parenting plan. And
hold on, we're not here on any of that.
Okay.
You all agree.
No, I'm just reviewing it. I'm not
Yeah, so just
arguing the fact.
argument on you want the county to pay your portion.
Okay, so I qualified like you stated. My net income is below the 125 FPL. Like you stated, I was granted the waiver fee in the beginning. The GR 34 allows the court to waive fees or surcharges of payments of which a condition to to my ability to secure access to judicial relief. I have fully disclosed all my income, even the income not at my disposal. County assistant for me for the GAL fee does not provide prejudice to Mr. Sanchez. In fact, the GAL has waived her hourly fee at a reduced rate if the county does pay, and this will benefit Mr. Sanchez as well as our children. I don't know what else I can say, but if you have any questions for me.
Sure. Thank you, ma'am. Mr. Sherm?
Yes, Your Honor. As stated previously, one of the reasons why I haven't signed off on the order, because I don't believe it's my or ability to agree to a county pay. However, when dealing with these issues on who's going to pay the GAL, typically the court does a deep dive into the financial abilities of the parties. Despite what Ms. Magalonis has stated, she has not provided any proof of her financial source documents. We don't have pay that have been provided to this court. We do have a financial declaration that shows surplus income, where mom's income is, when you calculate everything in here, is about just shy of $7,000 a month take home. That's not indigency, Your Honor. Mother has the ability to litigate in this. We have been back and forth, and I can't speak to the waiver of filing fees that she received when she filed this because I was part of the case then. I don't know what proof or evidence she provided to the court to get that. However, sitting here today, she wasn't found to be indigent in the administrative hearing when child support was ruled. As my client was granted a client and there was an Avery split. Additionally, we have had to fight and deal with almost every aspect of this case. And my fear is that if mother doesn't have to pay her share of it, again, she's going to be running up the GAL costs, a lot like the costs that have been driven up in this case with attorney fees, because we haven't been able to get compliance. Now, she has hired a triple LT that has been assisting on the case and that has promoted collaboration in this case, and we've gotten a lot farther on things. Communication has greatly increased, so I do appreciate Ms. Magalonis taking those steps. However, I think it's imperative of me as an officer of this court to look out to the best interests of how taxpayers' dollars are being distributed. And when someone brings a financial source document that shows surplus income, does not show indigency, but then also fails to provide her pay stubs and W-2 before this court, I think the court can see that and order appropriately. I just didn't believe it was in my best interest, the court's best interest, or on behalf of my client to sign on a GL order that granted her county pay. So that is our position today, Your Honor. I do believe, despite her making more income than my client, that a 50 split of the GAL cost is fair and equitable. And that would be our position, that it be 50-50, whether the court grants a county pay or the court indicates mother needs to pay her share. That's our position, Your Honor. If you have any further questions regarding that, that's just our position. Thank you.
Thank you. Ms. Magalonis, do you have any brief reply? I'll give you 30 seconds or so, and then
Yes, I provided the court with paycheck stubs as well as the DCS order, which showed that the income of Mr. Sanchez and mine are only 2% difference. And that is based off my income and Mr. Sanchez's. It does not include his partner, which is providing the money to be able to have the attorney, which is at a disadvantage for myself. So there are 2 incomes as well as 3 other adults in Mr. Sanchez's home, which he's not including, but yet is asking for me to include the 18-year-old that works part-time. So I'm just saying that there is a prejudice against Mr. Sherman and Mr. Sanchez against me receiving any kind of financial assistance, which I don't understand why. There is a GAL cap that I believe that we have an understanding that it's only capped at 2,000, so we're not going to be requesting more time as Mr. Sherman is predicting. And like I did provide paycheck stubs to him and the court. So there is no difference in the income of Mr. Sanchez and mine, except for he has a partner that makes the same amount and is helping him obtain legal counsel. And so I believe because of this, there is a difference in relief of judicial relief. And because of that, and the children that I provide so financial support that I believe without assisting me or even partly assisting me, it would affect greatly my income, especially after the newly child support placed on me. Even though Mr. Sanchez says finances are not an issue, if he's financially doing good, why is he putting child support on me? And there is currently not an Avery split like Mr. Sherman is declaring. There is two separate orders.
Okay. So this is on for the, as indicated, the payment allocation for the GA. Judge Hill, back on June 27th of 2024, did sign an order, a waiver of civil fees and surcharges. He did make a finding at that time that Ms. Magalonis had household income above 125% of the federal poverty guidelines, but cannot meet basic household living expenses and pay the fees and or surcharges. He also marked another finding that she had a continued need, and he did waive all fees and surcharges. That was done 7 months ago. Now, the information has changed, but it hasn't changed tremendously. The materials presented to Judge Hill did indicate that the mother was receiving TANF. Now, there's been further information that the TANF the mother's receiving is a non-need based TANF. It is it's non-needy TANF or dependency TANF. It's not based on she's taking care of kids that are that aren't hers. And so my understanding is even Bill Gates would be eligible for non-needy TANF if he took in foster kids that weren't his own kids. So, however, the information that Judge Hill, that distinction wasn't provided in front of Judge Hill, but Judge Hill's ruling that the mother is entitled to a waiver of fees and surcharges wasn't based entirely on TANF, but it was based on need. And that is listed in the criteria. Like I said, I do have some financial information. It is a close call here, but the court's going to find that the mother, based on all the material in front of it and the previous finding in June, that she is eligible for for waiver of fees, that the court will order county pay on her portion. I'll order a 50-50 split. As always, it's even in the order, it says that upon further review, a reallocation can be ordered. So, ma'am, this isn't it's, if more information comes to light, if your finances change, you can be ordered to pay or repay parts of the funds that have already been appropriated out. So, but I will do that. Just so everyone knows, the father is free to apply as well if he so desires and thinks he can qualify. It's the court can only rule on what's in front of it. So I will find that. So Mr. Sherm, I think the mom had actually filed a proposed order appointing guardian ad litem. I can change the situation there to show that it's going to be $100 an hour for Miss Lotstein, because I know when it's county pay, it's $100, and I guess she does that for the whole case. So do you want me to print that order out? It is a 50-50 split. It does have the language in there. about if the parties' financial arrangements change, the court may order the parties to pay the fees according to their ability to pay. So that at county expense for the mother, like I said, it is subject to reallocation. Is there anything else in that order? If I print that out, change Miss Lostein's hourly rate to 100, I'll leave it at the $2,000 cap. That does provide at least you have to come back into court to, if that's going to get exceeded, so that, you know, no one's trying to run up any fees or costs. But do you want me to get that signed? You were.
Yes, Your Honor, I approve the form of that order. Like I said in the beginning of my argument, it's just I didn't think it was incumbent on me to agree to an order that the court had made a ruling on. But I do agree with the form of the order. And with the court ruling at the county pay, I do believe, other than changing the hourly rate, that it's compliant with what the court is ordering and how to move forward.
Okay. I will print, Madam Clerk, can you have them print out sub-doc 97 for me, and then I'll cross out proposed and change the hourly rate and get that signed, and we get that to Ms. Lotsey so she can get started. All right, thanks.
Thank you, Your Honor.
Thank you, Your Honor.
No, the way, yeah, it's already been, I'm approving county pay. Okay. Yep, it is. There'd been one filed earlier. I'm granting the motion for the county pay based on those reasons. All right. All right, do we have, is Mr. McGee present?
Yes, Your Honor. I'm right here. Thank you.
Let's take, I was going to do this one a little earlier, but it's the Smedley and Teray matter, 22-3-164-13. Ms. Smedley, you're present?
Your Honor, this is Nakia Smedley on Zoom.
Okay, thank you. All right, thanks. So preliminarily, all right, Ms. Smedley, Mr. McGee has raised an objection that the current order in effect is not the order that you moved for contempt under. So we need to address that first. And are you in agreement that when you signed the request for contempt on December 7th, that April 16th order, or April 6th, or whatever, the April order had been superseded by the December 6th order that was signed by Judge Nodell?
I'm sorry, I'm not aware of any objection, so I guess I'm not prepared to address that.
Okay, Mr. McGee, did you get your objection?
Absolutely, Your Honor. It was emailed to her yesterday, and we put it in the mail. So if she needs a week to figure it out, I have no objection to that.
Okay.
But if she just check her email, she'd have all the materials there.
I have not agreed to electronic service. This is an issue I've brought up before the court many, many, many times.
I know. And you guys have been in front of Judge Nodell for the last little bit. And now, so.
Your Honor,
yeah.
The respondent in this case was served with these documents on December 26th. He's had over a month to respond. His response deadline was on Monday. At the last hearing on January 10th, I specifically addressed the issue of late filings with the court and was denied my request to have a response date set to avoid this issue. This is a tactic that James and his client has played for the last 3 years. You look at the docket, every one of their response or reply filings are done late, and it's always, due to business and sick and whatever else. It's the same story over and over and over. I would ask that the court strike whatever response was filed late, and let's just proceed with the hearing today.
Well, here's the issue. So the facts of the case are as follows. There was an order entered in April that ordered the dad to pay child support. And the parties had this, I don't know what happened in front of, it's like it took 2 years to have a child support and attorney's fees trial, and it took how many, you're up to 12 files, and it's on appeal. And there was an order entered in April 16th. That order was changed on reconsideration, as near as I can tell, because again, I wasn't the judicial officer hearing this, and it is a mess, on December 6th. However, that order, while it changed some things, it didn't change the start date of the child support, and it didn't change the amount. So, Mr. McGee, you're both right and wrong. And Ms. Smedley, we can have the hearing today. I'm just probably going to have to kick it. The problem is Mr. McGee, you're objecting to the order. You're probably right that Ms. Smedley cited the wrong order that wasn't in effect at the time she filed for contempt. It had been superseded. However, the operative parts of that order, while it changed parts of it, it didn't change the start date or the amount. So it's one of those things that,
Your Honor,
this is kind of, it's Mr. McGee, you put in this objection to the form, it's a procedural issue, but you haven't really addressed whether or not the child support's been paid, and I got DCS records that show they haven't been. I can kick it over. It just ramps up the fees and costs that are being charged in your client, but Ms. Medley, yeah.
my motion for contempt addressed the time period that the April order was in effect. So it was signed April 19th, effective April 2024. The motion that I filed and the supporting documents are all related to April through November 2024. So that December 6th order, it was effective April, but from April through November, that December 6th order didn't exist yet. Sure, it was filed in December, but the time period that it covers is still under the April 19th order. So I guess I'm confused about what the objection is. Are we saying that April order was not a valid order?
Stop.
And that it can be ignored until a new order is modified, or what are we suggesting here?
No. If you had filed your motion in December prior to that new order getting put in place, yes, it could proceed. Arguably, but again, it's almost a difference without a distinction. Again, because the correct order doesn't change the operative parts that are actually being requested. So, Mr. McGee, that's why I'm kind of saying, I mean, yes, you're probably right. However, and I'm going to give a chance to, say if there is some law that says, this is...
Your Honor, I don't know. Where is Miss Medley? She works in a big law firm, so she has access to Lexis and Westlaw and whatnot. And if she can come up with some case, please don't interrupt Miss Medley. The court gave me the floor.
Mr. McGee, stop. All right. Here's what the court's doing. We've got a big docket. It's 10:30, and I have to be gone in the afternoon. So here's what the court is doing. I have already said what I've said. Parties can take with it what they want. I think it's a difference without a distinction. However, I am going to, Mr. McGee, your documents were late. However, I can't really strike them. It's an objection. I will continue the case and let you guys see if you want to argue about, as I said, the operative parts of the order really didn't change, but the order cited In order to have contempt, there has to be a valid court order in existence at the time that you requested the contempt. And as it turns out, it wasn't. It was just shortly after, probably wasn't even in the file at the time, but it was in effect. Ergo, I'm going to set this over 2 weeks because next week is a mess. Set over to the 14th. You guys want to talk about this? What?
Yeah, I'm sorry. I'm actually on a flight on the 14th. We could go to the 20. I'm gone I'm here the 7th and I'm here on the 28th, but I'm gone the 14th and 21st in a foreign country.
Okay.
So Miss Medley, we could do it on the 7th or the 28th.
I'm not available the 7th.
You want to go to the 7th?
No, I'm not available the 7th.
Okay, 28th?
Yep. I'm good with it. Thank you.
Hold on. Miss Medley, the 28th work?
But I mean, at this point, let's set it to like March something. That way Mr. McGee can, get his whatever in a row so he can file timely. I mean, was there a motion to shorten time to file late? Like, I'm trying to understand the procedures here. I know back, June 6th, Mr. McGee explained to me that, he has this special privilege in Grant County that allows him to file documents, the day before or even the day of hearings, which is a prejudice against opposing parties, if they're up against Mr. McGee. I'm not convinced that, that's legal or valid, like that's appropriate, but that's what he claimed. And that appears to be true based on my experience with his filings in this court. It's
all right. Like I said, it's late. We're not going to have the hearing today. Nobody has any sort of special privileges. The court can see the order that was requested for contempt on December 7th, when you signed it, and December 10th, when it was signed by the court, was no longer in effect at the time that it was signed. However, like I said, the order that replaces it says on the operative portions the exact same stuff. Mr. McGee, your objection about the order is technically correct. However, the fact that you say it was changed, parts of it were changed, but not the parts that actually she's asking for contempt on. However, you have to have a valid court order to find contempt. I'm going to set it over to the 28th. Unless, Miss Medley, are you not here on the 28th? You guys we'll see what's going on. I've said what I've said. So do you want some date in March, Miss Medley? Whatever date you want.
I'm checking.
By. Well, yeah. Do you want the 28th of February or a different date?
28th should work.
Okay. 28th of February.
I'm okay on the
okay
14th if she wants that. It's I think it's going to be the same result because there's the invalid or the no longer in effect order, but I don't know what. I did the research on it, Your Honor. To the
28th. I don't want to.
Okay. Okay. We're okay. Okay, 28th it shall be.
All right. 28th. 28th final answer. It's 10:30, 10:35. We need to take the morning break. We're going to take the morning break now. And we will clear the courtroom so the clerk can have a break as well. And we will be back at, what time do we got? At 10:50. Be back at 10:50. All right. Thank you. I'll mute things, leave WebEx up. Okay, Mr. Huberto, can you hear and see the court? We're back.
I can.
Okay, perfect. All right, we're gonna see how many, if we can get through all of them, or, at least get close to most
Your
of them.
Honor, Mr. Huberto and I have a relatively straightforward motion. I don't know if the court would like to take that one up.
The Waters and Hart one,
Yes.
we can. So this is the Waters and Hart one, 25-3, 5-13. No kids, just dog in a house.
2 dogs.
2 dogs.
No kids, 2 dogs in a house, Your Honor.
All right, 3 guys. What was it? 3 guys, a girl, and a pizza place was a show 20 years ago. I'm showing my age. All right, I think it's Miss Stewart's motion, right?
Correct.
That's Your Honor. Excuse me. It is my motion, and Your Honor, in reviewing my file today, it does appear that the spouses seem to be in agreement that they will each be responsible for their own auto insurance. So that's one issue we can check the box on. That leaves the remaining issue of who is going to have temporary use and possession of the family home while the action is pending, and who's going to be taking care of the family dogs during the pendency of the action. What we are requesting is that Miss Waters Hart be given temporary use and possession of the family home, and we make that request for a couple different reasons. First and foremost is that Miss Waters Hart has been the spouse who's been primarily responsible for ensuring that the mortgage gets paid. Now, marital community funds are used to make that payment, but she has always coordinated the household's finances. It is correct that Mr. Hart is not identified on the bank account that's used to pay for the household expenses, but he has had access to a debit card to be able to use those funds as he needs or however he sees fit. But our position is that Miss Waters Hart is in a better financial position to continue managing the finances with respect to the home, making the mortgage payments on time. And I'm concerned about Mr. Hart's request in his response and in his proposed order. It appears that he's asking for use and possession of the family home, but he also wants my client to still pay half of the mortgage and half of the utilities and half of the property taxes and insurance. Now, the property taxes and insurance may be a different type of issue, but it would not be equitable for her to be ordered to vacate the home, but then still be responsible for 1/2 of the mortgage. And what that leads me to believe is if he's asking the court to divide that payment in half, that leads me to believe that he does not have the ability to ensure that the mortgage gets paid in full on his own. The other issue that we need to address is the 2 family dogs. My client has been the primary caregiver, for lack of a better word, for these dogs. It is correct that one of the dogs was acquired by Mr. Hart prior to the marriage, but throughout the marriage, really since that dog was acquired, Miss Waters Hart has been the one taking care of the dogs. She provides them with all their necessary daily supplies. She also works at Petco and gets a discount and is able to continue providing those supplies for the dogs. And the family home does have a fully fenced backyard. Mr. Hart, my understanding is that he may have in the past suggested that each spouse take 1 dog, but I don't think that would be in the dog's best interest to be separated. And I understand that dogs are considered personal property. They're not children. As much as we feel that by the law, they're not considered children. So the court has to figure out who's going to have use and possession of them during the pendency of the divorce. Now, when I make that statement, that is not to offend anybody that believes their pets are children. I'm just talking about what the law requires. But dogs are a part of the family. And ripping these 2 dogs apart and then suddenly removing Miss Waters Hart from the dogs' lives would not be best for them. It would not be best for these animals to be separated from their primary caregiver. My client is more than willing to agree to a reasonable schedule for who's going to have the dogs and when. She has no objection to Mr. Hart taking the dogs out to hunt whenever he sees fit. We're not contesting the fact that he is a hunting guide and he does require use of the dogs. But maintaining their environment and the structure of their routine right now is really important for them. So on that note, Your Honor, we are requesting that my client be granted temporary use and possession of the family home, including the 2 dogs. Each spouse should maintain use and possession of the vehicles that they currently have. My client has a couple extra vehicles that are, I believe, are her separate property, but she'll maintain the insurance and the maintenance on those vehicles on her own. We ask that Mr. Hart be responsible for any expenses associated with his vehicle. Regarding living arrangements, I want to point out to the court that my client moving into her deceased father's home is just simply not feasible at this time. It's not only was there quite a bit of abuse in her childhood that occurred in that home, but the home is also kind of in a state of disarray right now because the flooring is torn up as my client has been working on replacing the flooring to get the property ready to sell. And the home hopefully will be sold in the immediate future, which would essentially just displace her if the court will order her to live there. She unfortunately cannot go live with her mother due to the circumstances in that household. However, Mr. Hart does have the ability to reside with his parents. My understanding is that there are 2 bedrooms available to him that he could use until the couple sorts things out in the divorce. So we're asking that my client be allowed to stay in the home. And with that, I'll reserve any additional time that I have for any questions the court may have. Thank you.
Huberto.
Thank you, Your Honor. Starting off with the things we do agree. Ms. Hart had asked in her motion for some various vehicles to be awarded each party. We're fine with that. We just had to identify that one of them was an 08 and not, I think, a 2020. But we agree to whatever proposed distribution of the vehicles. We agree to what I would call the standard financial restraints. Sounds like we agree on the auto insurance. They each pay their own. And then lastly, my client will agree to keep her on his health insurance. He's employed through the federal government, so I suspect it's probably good insurance. He has no intention of taking her off, and that can be in the temporary order. So those things are all agreed. Really, it comes down to the dogs and the house, but most importantly, just the house, of course. This is a situation that, if I can be so blunt, that it's a short-term marriage. They were married in August of 2020. They don't have any kids together. This shouldn't be that complicated. If Ms. Hart wants a divorce, fine, she can have a divorce. If Ms. Hart no longer wants to reside together with my client, fine. Quite frankly, she can move. And that's what I don't understand. And the difficulty with this motion is she wants to kick my client out. And for what? Because it's convenient for her. She's the one who wants to leave. Go ahead and leave. If you look at the options, she files in her motion that, well, my client can move out with his parents. He files in his responsive declaration exactly why he can't move out and live with his parents, despite the inconvenience and his lack of desire to do so, but he can't. He doesn't have any other family in the area, can't move out. Of course, he points out, well, she has her dad's house that she inherited. She has her mom's home, who also resides in the area. What we get in a reply declaration from Ms. Hart says that, well, I can't continue living together. Although he's not physically abusive yet, she says it is emotionally unsafe for them to continue to reside together, although they've been residing together with an issue with their marriage for previous, 9 months. They've been going to counseling, but it's emotionally unsafe. Then she talked about her mom's home. She uses those terms again. She says her mom's home is emotionally unsafe for her to be there because her mom and stepdad are currently going through divorce. I understand why her dad's home is emotional for her. Granted, her dad passed away, I think 3 years ago, but I understand she doesn't want to reside there. But the fourth option is she can go rent someplace. We don't have financial declarations. This is very new to us. My client doesn't have access to the bank account that she uses. He has no idea of what her income is, other than the fact that she has 2 jobs. And according to her, and she received significant amount of money in inheritance, which apparently is down to, on page 4 of her recent reply declaration, which my client hasn't even seen yet. She's down to $20,000 from life insurance proceeds from her father. She can certainly go find a new place to rent if she wants to move out. There's not any physical concerns. As far as the dogs, as Ms. Stewart points out, they are personal property. I'm not trying to be disrespectful to anyone's emotions tied to dogs, but we're here in front of the court for the court to decide the issue on the law. The law says they're treated like personal property. One of those dogs, there's no dispute, is my client's separate property. Plus, as everyone agrees, my client provides guide services. He works for Fish and Wildlife for the federal government. The dogs are paramount to his livelihood. He uses them on a regular basis. They're his dogs. He'd like to keep them. Lastly, as far as the mortgage on the home, we didn't address as far them. If they continue to live together, they should continue to split the mortgage. Quite frankly, that's what should happen. It's what's fair, especially until we know more about the party's financial status outside of what we already do. If Ms. Hart moves out, my client will pay the full mortgage if he's going to continue to reside there. So unless your honor has any questions, those are our position on the issues. And I think they are pretty straightforward.
Okay, thanks. All right, I just have a question for each of you, basically. Ms. Stewart, if I were to award the house to your client, how much time should the husband have to move out? I'm not going to kick him out today, but how much time should he have?
One moment, Your Honor. My client would be willing to agree to as much as a month to give him a chance to get situated.
Okay. Mr. Huberto, if I kick the mom out, how much time should I give her to move out?
Whatever she wants. He's fine if they continue to reside in different rooms. Like I said, there's not any physical concern about them being in the same house. So however long it takes.
All right. I'll make one, I guess, observation and comment, and then I'll rule. On the house, whoever gets the house is going to have to pay it. If they can stay living there, then it can be split. I would also indicate that if they can both stay, that resolves the dog issue. Yeah. But assuming they can't both stay, I typically give at least 45 to 60 days for a spouse to get out, unless there's domestic violence and you're having to kick them out right then. But, there's going to be some time to let the spouse move out. So, Ms. Stewart, I saw your reply. Your client doesn't want to both live in the same house, right? You can't have separate bedrooms and War of the Roses. None of that.
I don't think so. As much as I wish that was a possibility, I mean, obviously that would save both parties money and some stress in finding new living arrangements. That's just not feasible. And I really don't think it's in either party's best interest for them to be going through a divorce but still living under the same household. It's just not the dynamic that we have here. My client just indicated that she has no objection to the court giving Mr. Hart 45 to 60 days.
Okay. Well, arguably, if they could agree to both live in the same house, that resolves most of the issues. However, since they can't, I have limited financial information. I have a statement from the husband that he makes about $40,000 a year, and I have a statement from the wife that she works 2 jobs and says he makes more than her. He claims in his declaration that he makes $40,000 a year and she makes more than him. But I have no pay stubs and no finances of any sort. They might have put in there what the mortgage is, but I don't even think I have what the mortgage is. So if I have to rule, what I'm going to do is this. I'm going to award the house to the wife temporarily to use it. I think she probably has at least a little better ability to pay for it and keep it afloat. She has to pay all the expenses with it. I will give the husband 60 days, 2 months to find another place and move out. Her name is on the loan. I know why in the declarations. That really doesn't matter, but I got to award it to someone. You both have reasons why you want it. You both have reasons why the other person should move out and where they can move to. I don't really care where. I'm not going to order the husband to move anywhere. Any particular place, he just can't live there. He can live any other place that he wants to secure. For the same reason that since I have to award the house to one, I have to award the dogs. They are property. It's undisputed that one of the dogs is a separate property of the husband. I'm going to give both dogs to the husband. And that's all I really can do. I have to give them to someone. I'm not going to split them up. They're property. It's just like cars. It's undisputed that it's separate property of one and he uses them in his business. We really don't get into discussions about who takes care of them. This isn't who has a stronger bond or what's least disruptive to their emotional stability. It's property. It's who uses them. It's like a car that may not be how people think about it, but it's what the law describes. So husband gets the dogs, wife gets the house, husband has 60 days to move out. And, you know, that gives them all the way to basically, you know, to be out by March 31st. That gives him, you know, into a new place on April 1st. If he can move out sooner, great. If the parties agree to something else in the meantime, more power to them.
And so the wife pays the mortgage and taxes and insurance with it, correct?
I will, whoever gets the house has to pay for it. All the expenses related to it on a temporary basis until you decide how it's going to get divided and what's used and blah, blah, blah. You know, community and separate funds, all that kind of stuff. I will order the standard financial restraints and the agreement regarding the vehicles and everything else that you guys all agreed to. So anything else, Miss Stewart?
I'm wondering, just thinking out loud here, Mr. Huberto, feel free to jump in. Given that my client has also used the dogs because they are personal property, I'm just going to use that terminology. Would it be possible for these parties to enjoy shared time with the dogs? Would the court be willing to entertain such a request?
I've ruled what I've ruled. The parties are free to do what they want.
Okay.
By agreement, you got 60 days to figure everything out, or less, depending on who's moving where.
Okay.
I have a vested interest. If you guys arrive at some other resolution, it's fine. As far as, do you want me to enter? I do have a temporary order from Mr. Huberto. That can be marked up, or do you want to?
You can probably just indicate respondent, switch to respondent and petitioner on the home issue, and I think that probably solves everything.
Yeah, that
well, that and the home, the home mortgage. Let me pull that up. However, Your Honor would like to do it.
Because I think in Mr. Huberto's order, he had the parties splitting the mortgage, so you just have to interlineate some language there.
Oh, actually, the way I drafted is so the court could actually cross one out. Now I recall, so you could just cross off who's the petitioner is. So we just cross off respondent under paragraph 9, so that way it shows she's paying.
I did that, and you got the premiums in there. As far as the dogs, I guess I just need to put under other property, the dogs will stay with the respondent. That's in there. Okay, yep. So I crossed out respondent, put petitioner for staying in the family home, crossed out the respondent for paying the mortgages, utilities, and insurance on the family home. Obviously, he has to pay his own once he moves out.
And then there's a little sentence under other, Your Honor, you'll need to strike out. It starts with underneath other, and under paragraph 9 on page 3, it says the mortgage. If you can just put a line through that. I think that's probably what Ms. Stewart was referring to.
Okay. Work for everyone?
Yes, Your Honor. Thank you.
All right. Thanks.
Thanks.
I've signed the order. Just stating what the law is on animals. I don't want any angry notes from, I like animals.
None taken, Your Honor. You won't get a hate letter from PETA or anything.
Okay. Let's go ahead and take the Sharpnack matter. That is cause number 11-393-5. It's Mr. Anderson and Mr. Sharpnack. Mr. Sharpnack, can you state your name for the record?
John Sharpnack.
Okay, and you are the petitioner in the matter, correct?
Yes.
And you don't have an attorney?
Nope.
Mr. Anderson, you represent the mother. Is she here or with you, or?
She is present, sitting across the desk from me, Your Honor.
I got something stuck in my throat. I'm a little tickle in the throat. So, okay. This is here on the motion. It's a motion for contempt and a temporary show cause order. Mr. Sharpnack, you didn't supply any updated declaration?
No, I looked at everything and I just got to the point where I'm just not going to respond to lies. They have not brought any proof to the court on anything. But yeah, I have to bring proof of everything that I say to the court. You know, I proved that this home is not fit for a child. My child refuses to go back. She refuses to call her mom. we put her back in the home, she's going to continue to run away. You know, she showed up at my house back in December. 3 days later, the cops show up. They see her there. They said, well, contact Ephrata PD and let them know, but we're not going to remove her. But she refuses to go back.
Okay. I just want to make sure, I didn't see that you'd filed anything more, so
No.
I just wanted to make sure. Because it was continued, so you could do that. But I also know you hadn't seen it, so if you looked at everything and are ready to go, then that's fine. I just wanted to make sure. All right. So we're here on, they're flip sides of the same coin, you know, as far as Mr. Sharpneck's motion to switch custody and Mr. or Miss Rodriguez's motion on contempt. They're just the flip side because everyone agrees the daughter's not following the parenting plan. It's just, you know, what do we need to do about it? So, all right. I'll hear from both of you and we'll go from there. So, Mr. Sharpneck, you kind of started and said some stuff. Do you have anything else you want to let me know?
Yeah, I provided the police reports that show what goes on in this household, which I did back in September, was not a safe home. But yet they come into this courtroom and they have not provided anything they have said in their declarations, they have not had proof. But why am I the one that's getting picked on by this court by removing my child and putting her in a home that was not safe? I don't think it was fair. Not fair to the child. My child has cuts on her arms for cutting herself for being in that home. It is not safe for her to be there. And if you want to get me for contempt, go ahead. I was just trying to protect my child, and I will not comply with a contempt order.
Oh, okay. But you guys had an agreed parenting plan that got presented.
The stuff that was supposed to be put in that parenting plan was, they didn't want to, people from the DRC did not want to put it in. Well, we can't put that in there because I wanted to left up the child for when she wanted to spend the time overnights gradually, but they said they couldn't do that. And then she didn't even want to comply with what we talked about in there.
Okay. Mr. Anderson?
I guess, first of all, Your Honor, we need to a little bit make sure everybody understands the history. Back in, I believe it was February of last year, the parties went to the DRC and they mediated out a temporary, what they said was a temporary parenting plan. At that time, it gave mom, I believe it was every other weekend visits. And over the course of the summer, the child was left here in Grant County, showed up at mom's house, said, hey, I have no place to go. Mom took her in. We filed a motion to, in essence, amend that temporary parenting plan, which the court heard and which the court granted in September of last year, placing mom as the primary residential parent. Mr. Sharpneck provided a declaration full of child hearsay, full of hearsay of things that he had heard, things that he was told. He supplied, as he says, I supplied proof in the form of police reports. The police reports are 2 to 3 or more years old, number one. Number two, they were previously provided to the court when the court heard this matter back in September and the court made its decision to place the child with mom. Nothing new has changed. Basically what happened was the daughter had wanted to go out with a friend of hers that mom did not approve of. Mom said no. Then the daughter makes all these allegations against her stepfather. We provided proof. We provided a letter from Child Protective Services that said they investigated these allegations and they were unfounded. Police recall that at I guess the hospital the night when these allegations were first made and said, you know, there's nothing there. And in fact, the child was returned to the home, I believe 2 days later. And then it was after that this whole thing blew up. The daughter went to her visits with the dad for that weekend, comes back, and as she's in the car, the dad says to the daughter, stick to the plan. Next thing you know, I believe it was the next day, she doesn't return home from school, and mom went and filed a runaway report. And for the longest time, Mr. Sharpneck said, I don't know where she's at. I had no contact with her. I'm sorry, we don't believe that. I think that he's known where she's been all along. Granted, that is my belief. That's mom's belief. We have no proof of that other than the fact that that Ms. Sharpnack then files this, his motion to change the parenting plan, again, based upon hearsay, based upon old police reports that have already been considered by the courts. And we were here in court 2 weeks ago. Of course, there is a current parenting plan in effect. It needs to be followed. Mr. Sharpnack has continued to not follow that parenting plan. He said, and he's done nothing to indicate that he's done anything in regards to, write out and trying to make sure that the daughter follows the parenting plan. At the very least, has phone contact with the mom, saying, well, she refuses to. What has he done to try to encourage her, to try to, I don't want to say coerce her, but try to get her to make contact with the mom? In my opinion, basically, we have a daughter who is unhappy that she was forced to follow rules, and so she makes up this story, and so that's why we're here today. We're asking that number one, the court deny the motion to change the parenting plan, and that the court find Mr. Sharpnack in contempt. Now, as far as if the court does find him in contempt, I don't know. I guess we could say, well, that he's withheld the child since the beginning of December. Therefore, we're going to cut into his time with the child to make up for the time that was missed by mom. I don't know if that's really practical, but we would be asking for the court to impose attorney's fees and the statutory civil penalty in this matter. I believe that's all I have at this time, Your Honor.
Okay, thank you, Mr. Anderson. Mr. Sharpnack, anything else? And I got a couple questions.
They sit there and say, I said, tell my daughter to stick to the plan. If I was to say something to my child, they were parked on the other side of the parking lot. So that's a goddamn lie right there. I'm just tired of coming here and have to listen to lies. And I'm tired of the court choosing sides, because that's what has happened. I have filed multiple complaints with this court, and now there is an investigation into you for what you did back in September. I am done. Somebody tries to come take my kid, there's going to be consequences. I am trying to protect her from this fucking court and them people. I've had enough.
You guys have, both parties agreed to adequate cause over 2 years ago. You guys both agreed you wanted to change the parenting plan 2 years ago. You haven't done anything for 2 years to finalize the parenting plan, other than you went to mediation, which was good. You reached an agreement, great. But you haven't got to a resolution. Why? It was 2 years ago. You both wanted the parenting plan changed. You've been to mediation. What is stopping the parties from getting a trial? Either reach an agreement. Sounds like you can't, right? I mean, why weren't you able to reach? If you're not able to reach an agreement, then you have a trial.
We're not. And as of right now, my kid is going to stay with me so I can protect her.
Okay. I'm just saying, you guys need to get to trial. You need to get a resolution to this. That's what's going on. There's been a couple temporary parenting plans. You moved. You were up in Spokane. I mean, the court placed the kid with you every weekend. And, the kid with the mom during the week, because you moved. You're up in Spokane. I mean, I don't know what. There's a parenting plan in effect. It gives you every weekend.
My child don't want to be in a home.
And it gives the mom every, during the week. Now, under write-out, the kids don't get to decide where they go. The parents.
But I do when it's a safety issue.
So you guys can, CPS is investigated. They did an investigation.
They told me there was not enough proof, which I understand that. But does not mean it did not happen.
No, I understand that. But when there's been an investigation and it's just on declarations, the court can't. You guys need to get to trial and get a final resolution. Then you can testify. You guys can sit up and testify and do whatever. I mean, you can present evidence. It's not just 10 minutes aside. That's what has to happen. You guys need to get to trial. Do you want this sent to the court administrator's office for a trial setting, Mr. Anderson?
Your Honor, I would. They've attempted mediation, so I think we've met all the obligations, and we just need to get this matter resolved finally.
So, Mr. Sharpnack, do you want me to send it to the court administrator's office for a trial setting?
Yep.
Okay. That's an easy one. I'll send it to the court administrator's office for a trial setting. What's going to happen, Mr. Sharpnack? You're going to get a letter from the court admin, and so is Mr. Anderson.
And it'll be to the address that's on my paperwork, right?
Yep, it'll be to whatever address you have in the court file.
Yeah, because it's a new address on that one there.
Okay.
It's the Post
Yep.
Falls address.
There's actually a change of address form, but if you put in here, they'll look at the most recent address. Whatever address you have in here is the most recent address. Is that on your notice of hearing?
Yep.
Okay. Can you flag that for the court admin? 188.
Oh, for address?
It's Post Falls, Idaho?
Yes.
That's mainly, okay. So
Sub 188?
sub 188 has Dad's address. He's going to send a letter to both you and Mr. Anderson asking for unavailable dates. If you've got some pre-planned vacation or surgery or something, it's going to give you a number of, a range of dates. And if you have anything that you can't be in court on those dates, then you put those unavailable dates. Then she'll set one, that works. Is it a 1-day trial, 2-day trial?
I believe 1 day should be plenty, Your Honor. There's no property issues or anything. It's just parenting plan.
1-day, 2-day trial. How many witnesses? Are you going to have a bunch of witnesses?
I may have several witnesses, yes.
Okay. Yourself and how many witnesses?
Could be up to 15.
Okay.
I guess
There's not a setup for a 2-day trial. I don't want to have a problem where we get partway through and have to strike things because we don't have enough time. I don't know how many witnesses you're going to have, but more than just your client?
Yeah, probably this is maybe 3, 4, but not. But okay. Yeah, I think a 2-day trial is necessary at this point, Your Honor.
If you have 3 or 4 witnesses, and if Mr. Sharpnack has, you said upwards of 15, I don't know if you'll have 15 that are going to have different things, different fact witnesses. If it gets cumulative, the court may say, it's cumulative. But in any event, we'll do 2 days so that there's plenty of time for everyone to get whatever witnesses. Because like I said, the last thing you want to do is have to strike it and start over. It's better to have, if you get done in a day, you get done in a day. So it'll be a 2-day trial. Look at the dates, and if there's any that conflict with anything that you have going on, it'll be set out a few months. She'll say, the letter will say something like April or May, between April and November of this year or something, and they'll set it in that time frame. So just look at that and get that back right away, because they'll set it as soon as they get both letters back, okay? So, and if you don't send any unavailable dates back, then they'll wait a couple weeks and then just set it, with no unavailable dates, assuming that you can be present for all dates.
Yeah.
Okay. So do that. That's an easy thing. All right. So there's a current parenting plan in place. That parenting plan has to be followed, until it's changed. And both parents have to ensure that the parenting plan is followed. And you have to encourage your child to follow the parenting plan, contact mom, go to moms during those times, and then mom's got to get the kid back to you, all that kind of stuff.
She, like I said, she refuses to go, and I don't think it's appropriate to put her in a home that she does not feel safe in.
I understand, but...
And I won't do it.
Okay. Well, you have to, and you can force her to. Now, if she's truly recalcitrant and won't go, and you punish her and ground her and all that kind of stuff, then, but you're not telling me that you're doing those things. You're encouraging.
I've encouraged her to call, that's it, but putting her in that home is just not safe.
Okay. Well, the thing is I don't, CPS is investigated. The police have investigated. The police reports you filed. I mean, I grant it, but they are older and there's nothing that goes on. Now, Mr. Anderson, if the child just runs away, I mean, there's, the court can't do anything about that. I can't physically make the child go anywhere. But sir, you got to get the child there and do what you can. Now, if she runs away and back to your house, she runs away.
I'll let her know. I'll call her when I leave here. And if she decides to take off from where I'm at in Post Falls, I ain't going to find her nowhere. I don't want her on the streets
No, I know.
running around. It's not safe.
Well, that's why you get her to the home in Ephrata, and then she's not going to run away. She'd run away in Ephrata. She's not going to run away from your home.
Still not safe.
Okay,
It's not even safe in that home.
I understand.
You guys do what you want.
So,
I'll do what I got to do.
okay. Mr. Sharpnack, you're going to get the letter from the court.
That's fine.
Admin, okay?
Kiss my ass too.
Okay. Yes.
Your Honor, is the court making a ruling as far as the contempt motion?
Yes, Mr. Sharpnack left. The court, the parenting plan has to be followed. He's not following it. The court will find contempt. That's all the court can do. Mr. Anderson, your client has to understand, though, too, the child's older, and I don't want the child on the streets. You guys need to get in front of the court for a trial and not just hearings on I don't know why this took 2 years, but he's in contempt. I'll find contempt and enter a contempt order.
And Your Honor, is the court going to award any civil penalty or attorney's fees on that?
Yeah, it's mandatory under the statute. So
Okay, I will.
If you guys want to, if you can't get anywhere, hopefully,
We just wait for another court date in the mail.
but you can file for something. I don't want to.
I understand, Your Honor. I've been talking to my clients about.
You're going to go to trial. Get to trial.
Yeah.
Give it to trial.
Okay.
Thank you, Your Honor.
Thanks. Yeah, I'll do an order. I'll keep file and I'll do an order at lunch. All right. All right. What do we have? We got the Gomez and Bonington matter. This is 23-3-318-13. Sir, can you state your name?
Cesar Gomez.
Okay, and you're the petitioner?
Yes.
Okay, is Mr. Heaps or Mr. Gilreath, are you covering for Mr. Heaps on this?
I'm covering, Your Honor. James Gilreath on behalf of Janet Bonington.
Okay, so this is on for a trial setting. Sir, you noted a trial setting. As far as I can tell from the file, you don't have compliance with the local rule for mandatory mediation. You haven't been to mediation or got mediation waived.
I've tried to get her to go at the DRC. There should be two files saying that she refused.
Okay, but so under the local rule, you have to either go to mediation or move to compel mediation or try to get a waiver for mediation. You didn't do any. You haven't been to mediation.
No.
You haven't got an order to compel mediation.
Your Honor.
Request the court to compel, and you haven't got mediation waived. So, Mr. Gilreath, where are we at? And I mean, is there a mediation?
If I may, right after temporary orders were set, I believe Mr. Gomez tried to set mediation with the DRC. We just received his responses to interrogatories this month, and we have set it for mediation with Jim Hatch. It should be in the mail to Mr. Gomez for those dates, but that should arrive next week. The attorney on this case wants to proceed to mediation. He just did not want to do so with the DRC.
You fine with mediating with the Hatches?
I'd rather just do it here if we can.
So, you guys,
I mean, I'm fine, totally fine with mediation.
And If I may, the hatches are available via Zoom. You won't have to drive anywhere. They're just former attorneys, or I guess Mr. Hatch is a current attorney, but they usually do a pretty good job. I believe or Commissioner Middleton spoke about them on the docket previously.
I'm old school, Judge. I'd rather go in person and
So here's the situation. You guys both want to mediate.
yeah, I don't
Want
have,
to mediate, right?
yeah, I don't have a problem
And
with it.
Mr. Gilreath's client wants to mediate. So mediation's what you need to do. If you guys can agree on the mediator, then it's great, no problem. If you can't agree on a mediator, then you have to file a motion and have the court decide.
Okay.
The problem with it on that is, which is fine, I can pick one. I have to know why you want the mediator you want and why the other mediator is not appropriate from both sides. Obviously, if you can both agree on one, it's kind of like we can only buy one flavor of ice cream. You know, somebody wants vanilla, the other wants chocolate.
Right.
Can you compromise on strawberry or something? And if not, then, you know, I just have to know. Now, if someone's definitely allergic to chocolate, then okay, and the other side just doesn't like vanilla quite as much as chocolate, but one's going to kill, you know, if they eat chocolate, then we're probably going to go with vanilla.
Right.
But, you know, I don't have any of that in front of me. You guys, so it's not appropriate for trial setting. You guys need to get to mediation. You both want to go to mediation. Talk to Mr. Gilreath and or Mr. Heaps about the DRC and hatches. The DRC is cheaper.
Yes.
They're here. I know the attorneys, the DRC and the attorneys all got crossways. There's a number of reasons why the hatches do a good job, but they cost more. I mean, there's all sorts. So like I said, if you guys can discuss it and see if you can reach an agreement, great. If not, I'll need a motion and I need to know why you don't want the other sides and why you want yours. And then I'll have to decide.
Okay.
And maybe you can come to a compromise somewhere. I don't know. If it's cost, maybe work it out. I don't know. So your motion's denied because you haven't been to mediation. It's really not properly before me on who can be the mediator. So you guys see if you can work it out. I don't think you want to come back to court for me to decide the flavor of ice cream.
Right.
Thank you, Your Honor.
Okay.
All right, thanks. We'll just talk to them and see if you guys can arrive and agree mediate.
Okay.
All right,
Thank you.
thanks. All right. What do we got left? Oh, man. Okay, let's do the Quintero and Arroyo, 24-3, 46-13.
Your Honor, Barb Black, present for Mr. Quintero, who is also present on the Zoom platform.
Okay, thank you. And is for Miss Arroyo, are you present? And I don't know, is the LLT helping you? I know they can now do that in court, but I don't know, she may or may not be. I think it's Miss Selden, right?
Correct, Your Honor. This is Miss Selden. I am on the Zoom.
Okay, and are you doing the presentation?
No, we're not allowed to argue for our clients in
Okay,
hearings. We're allowed to support them, sit with them at council table. Thank you for asking. Yes, but she and I are both in remote locations, so.
okay, that's fine. I couldn't remember. I knew there was some expansion of the roles, but I hadn't actually looked at what they were.
No problem. Your Honor, if you have a question for me on fact or procedure, I may answer those.
Okay, thanks.
Thank
All right,
you.
Miss Arroyo, there was an objection raised by Miss Black about the new issues on reply. So typically you can't raise new issues on reply. Did you want to address that preliminarily, really quickly, Miss Arroyo?
Yes.
Okay. There was an objection about you raised new
Well,
issues.
there's not really issues at the moment.
There's not issues? What do you mean?
Well, I'm not, well, could you clarify what the new issues that Black has?
Well, it's about it's new information such as the drug and medical records, whatnot. They weren't raised in his response.
And those were raised by Arroyo, not Black. So.
Oh, did I say that? Yeah.
No, she did. She said they were by us and they were
That
not.
that actually is a part of my request for custody.
Yeah, that.
Okay, so Ms. Arroyo, anything on the objection preliminarily?
No.
No, okay. So as far as the objection goes, Ms. Black is correct. You can't raise new issues on reply, and your reply declaration also exceeded the page limits. What the court is going to do, the portions about new information, such as drugs, medical records, etc., whatnot, that you hadn't raised in your initial materials and that weren't responded to by Mr. Quintero, I'm going to, I'll strike. However, the materials about the kids in school and taking care of Luis, that stuff all comes in because Mr. Quintero, Luis Quintero, he talked about that in his response, as well as about the enforcement of the parenting plan. You know, he talked about those things. So that stuff comes in. Basically, when I exclude the stuff that wasn't, that was raised, new issues that aren't strict reply were raised in reply, when that's excluded and the materials that that are properly, that were raised by Mr. Quintero are left in, that takes care of most age limit issues. So that's what the court's going to do. I will.
Can I just mention one thing, that the new issues didn't arise until after I filed my motion. That was the only reason why I added them.
Yeah, but we can't do that because then he doesn't have a chance to respond, you know. So the motion that you filed your motion, you have your supporting documents, he responds, you can reply and provide information about stuff that he responded about, but you can't add new information. That's why it's called a strict reply. And so the new information's out. The old information is in the stuff that was, you know, about the enforcement of the parenting plan, about the kids in school and taking care of him. You know, you dispute, you know, that you went over there and it was at his request, and you know, he talked about that, and all that stuff comes in because he raised it in response. You're allowed to reply to it. But
okay.
Nothing
Your Honor,
about the medical.
I might be able to get to the bottom of some of this a lot fairly quickly based on the response that my client provided, in which he stipulated to moving Luis and Gabriel to mother's home and having the alternating weekends. He stipulated to that, which she acknowledged.
Yeah.
And the older two children that are a little more problematic, I mean, the court has been, the motion before the court is to enforce the parenting plan. Well, that goes both ways. Mr. Quintero is no more in contempt for the older two children than she is for the younger two children, which is, they've basically been in her care more recently, which is why he's stipulating. So I don't know that we're really here on a anything other than when the court tells the parties, go by the parenting plan. We'll change the parenting plan to the two younger children in the primary custody of the mother. The two older children have been in the primary custody of dad, but the parenting plan says they're supposed to exchange for, you know, at reasonable times, and the parties have done that. Now, whether or not she feels they haven't done that, that is not properly before the court. And the court signed a denial of this notion of an immediate restraining order, which we only discovered on Odyssey. We were never served with any of that. And the motion says we were served both before and after the hearing, and we were not served either time. So we ended up having to get those documents off of Laserfish because we were never served with those. But again, none of that is before the court either. So I would like to have a limitation about what we really are here before the court on. It's to amend the temporary parenting plan, which we stipulated to for the two youngest, and to enforce the parenting plan, the other rest of it, the way it has been going. I guess she's moved for all four of the kids, but that's problematic, and I'm getting into my argument now, and I'll wait for the court to tell me when.
So, yeah, Miss Arroyo, it's your motion. We are here just on the modification and enforcement. We're not here on contempt. There's no motion to show cause, so go ahead. I've read the materials. There's no dispute about the younger two kids. Dad's agreed to custody. You guys just need to work out the details of the parenting plan. That'll be entered by agreement. So, for kids, go ahead.
In my motion to enforce the current teen parenting plan, on March 8th, 24th, that I noted that Luis has withheld our oldest, Hazel and Julian, since the entry of the plan. Luis has not denied this. He has only blamed it on the children and lied that they have run away from home repeatedly. In his declaration filed on the 27th of January, I'm asking the court to hold Luis accountable and to enforce our parenting plan. Luis has agreed to my request to the two youngest to reside with me primarily with weekend visits for Luis. This was my request in my motion to modify. Since following my motion to modify and enforce, I have learned that it appears Luis is indeed using fentanyl as I suspected and noted in my motion. Luis has appeared to have tested positive for fentanyl at the Columbia Basin Hospital emergency room, as well as for alcohol. After the car accident he got into on the 14th of January, the children and I went to the ER with Luis. When Luis called from the accident, I did read Luis the ER notes where it indicates his positive fentanyl test. Luis then stated someone must have put it in his lunch. This is similar to his previous deflections. Based on the positive fentanyl test, I filed a motion for immediate restraining order on the 28th of January. That was denied pending this hearing for my motion. For an immediate restraining order, I request immediate custody of the children if it's allowed and while Luis attends his drug dependency. While in Luis's primary custody, our two oldest children have fallen behind in their grades and attendance at school. The school has warned Luis, who has assumed primary custody of the two oldest children while withholding them, that our oldest, Hazel, is on the verge of truancy. While on the other hand, our 10-year-old, who is residing half-time with me, he is excelling in school. He's received honor roll. He's receiving awards for good behavior. And our youngest, I have placed him in preschool. Luis has agreed to giving me the custody for the 10 and the 3-year-old. And I believe with my full mother's heart that it is in the children's best interest to live with me while Luis deals with his drug dependency. I have a suitable housing, reside near the schools, am available to provide care and presence in the home for them during the school days. I'm attentive and an involved parent. In his reply declaration, Luis says he needs these children, Hazel and Julian, to be in his home to support him while he recovers from his car accident. This is unbelievably selfish and unreasonable. Luis has family members in Quincy who can help him. Our 19-year-old son lives with him. Hazel and Julian are already in trouble with the schools. This is another sign of Luis not understanding what it takes to be a mature, responsible parent and put our children's needs first. And responding to Luis's attorney's question on how I will keep the children from running away from home, my plan is to teach the children to follow rules and court orders. I hope exposure to my teachings and values will gain traction and the children will make good choices. A hair follicle test is really important so that we can make sure that Luis is in the right state of mind to fulfill the appropriate parental duties to help these children thrive and be successful and to follow rules and expectations. I ask the court to, yeah. Do you have any questions for me?
No, I don't. So Miss Black, you're in agreement with, you're gonna get a parenting plan worked
Yeah.
out
For
Roy.
Louis Gabriel.
for the younger kids. All right.
Yeah. And we will continue to request the access to the schools. Louise has had numerous absences, and which she hasn't explained, both excused and unexcused. So we will keep on that with all the kids. That's important. So just those two are the agreement. Julian, who is interesting to hear her say that, oh, he's withholding the kids. Julian has been in her house this week. So it's not exactly truthful to say he's been withholding the kids when one of them is staying with her. So.
All right. I don't.
Your Honor, can I reply to that really quick?
No, I want to finish my argument.
All right. And Miss Black, I don't need to hear from you. I've read the materials.
Well, and let me just ask. The line has been blurred about what's admissible and what's not. She's arguing from this so-called medical report. It is not at all what she says it is, and it isn't a proof of fentanyl use. And I think the court understood that when it denied her immediate motion. So I just want to point that out on the record. There is no evaluations and treatment and any of that stuff coming from Mr. Quintero. That is not what happened after his accident. So I think the court understood that from the letter that she provided. Oh, and one other thing, she also went into his home and took that letter from his home. She also took a letter that was addressed to him from the school that said Hazel had a truancy hearing, and she submitted it to the court along with her documents, and it was yesterday, and she didn't show up. Mr. Quintero, on crutches from his accident, showed up with Hazel to this hearing as a mature, responsible parent would do, and Ms. Arroyo was not there. So okay. I hope when the court's,
Your Honor, my situation is DV.
Plan here. I'm hoping that the court acknowledges that Mr. Quintero is doing what he needs to do in regards to parenting his children properly.
Okay, I know. I read them. So I ruled on what's admissible. Miss Arroyo.
I didn't think that was an issue she could bring up, that she argued for a minute. And the hair follicle test, I requested that he take it, and I could take it too.
Yeah, it's
like. All right, everyone. I'm going to rule. I don't need to hear from Miss Black. What this is on for, it's not on for contempt. There's no motion or order to show cause have been filed. The parents need to abide by the parenting plan that is in effect. So as far as that goes, there's no motion for contempt. I have already ruled on what's admissible and what's been stricken. The materials filed that were not in strict reply have already been stricken. I know Ms. Arroyo brought them up in her argument. The court can compartmentalize and disregard the material that is not properly before the court. So this is on for a motion to modify a temporary parenting plan and enforce a temporary parenting plan. There's been agreement for the parties to enter a new parenting plan for the two younger kids. That's great. Do it. Need to work out the details and get it signed by both of you and presented. Okay? That's for the two younger kids. As to the older kids, there's been no mediation, no request to waive mediation, no basis to modify a temporary parenting plan that's in effect. Mom came in and tried to get an emergency restraining order. It was denied. Ma'am, there's no agreement to modify the ones for the older kids. You haven't moved to waive mediation. You haven't been to mediation. There's no basis to modify the parenting plan that you supplied in your initial information and the appropriate material that's before the court that the dad's has received and has been able to respond to, and you've replied to. There's not a basis to change the parenting plan for the two older kids. So that's the court's ruling. There's no motion for contempt. I'm not finding anyone in contempt. Both parents need to follow the parenting plan that's in effect. The older kids, you need to follow it. Both need to make sure it happens. If you want to try to move for contempt, the parties can. You can work things out, get to mediation and get an agreement, or get to mediation, don't reach an agreement and get to trial. But as far as the motion to modify the temporary parenting plan for the older kids, it's denied. There's not a basis to do so. That's before the court properly right now.
Will we still get, will you ask for the hair follicle test? And if so, will there be can I get a deadline to it?
No, I'm not ordering any of that material. You guys have a temporary parenting plan in place. I'm not modifying the parenting plan to start requiring testing and everything else. That's denied. You guys go through, either reach an agreement or get to mediation and then get to trial if you're unable to reach an agreement at mediation. So, and if there's been a substantial change in circumstances on a temporary parenting plan, you can come in, but I'm not finding it for the reasons of that's for the materials supported the motion that are properly before the court. So, you guys can reach an agreement on the two younger kids plan. You guys can change it by agreement all you want. But, all right.
We'll circulate orders, Your Honor.
Okay, thanks.
Thank you.
Okay, we've got, we can go into the lunch hour a little bit. I have to get going, but we'll see where we have. We've got the Shearer matter. This is 24-3-147-13. Mr. Anderson and Mr. McGee.
Your Honor.
Morning, Your Honor. James McGee here.
Obviously, it's not going to get heard today.
Probably.
We just get an order of continuance on both the reissuance of the protection order and either continue that or do a special.
We can, yeah, we can try to deal with some of those. We can deal with a couple of those before we take up the Shearer matter. So on the Jessup, right? Is it Jessup? Yeah.
Yes.
All right. So we got a couple options here. I was hoping we could get to them, but I know.
I'm realistic and
parties,
I have a 1 o'clock mediation, so I can't be here in the afternoon.
Are parties available on Monday?
Let me look at my
For a
calendar.
special, I mean, I've got Monday and we can set it over to Monday in the morning or the afternoon, and you can have a little, there's a number of issues with this case, a number of issues that the parties have presented that's not going to take 10 minutes aside, probably.
Right.
So Mr. McGee, are you available on Monday?
Yeah, I can make that work. I would like to make sure that my client has this. Excuse me, we had trouble with interruptions last time. Let's not do it again. My client would like to ensure that, he's been seeing his kids regularly. He'd certainly like to have them for the weekend here.
You had him
again.
last weekend.
So we would like to, but yeah, I can make that work, Your Honor. I appreciate the offer of the special set.
Okay, so you can do Monday.
Yep. Yes, sir. Anytime.
For 1 o'clock or what? I don't know what time you guys get done with lunch. So 1:30, whatever it is.
Okay. The afternoon work for you?
Yes, Your Honor.
Okay. We can do 1:30.
Okay.
Yes.
There is I have a 2 o'clock ex parte I might have to break for 5 minutes and do something, or they might get a different judge to do it. It just depends on all the availability of stuff.
I could do an 11 o'clock also. I can't do a 9 o'clock. Whichever works for you.
It doesn't matter to me.
Mr. McGee?
Probably 1:30 is a little more efficient for me.
We'll do 1:30. So I did see that, Judge, you guys agreed to the every other weekend, and it was mom's weekend or dad's weekend last weekend. So we're just going to go to Monday. I don't think Mr. McGee it's been every other weekend. That's not prejudicial to anyone. I know you both want custody and everything else. So, but since we're just going to Monday, I'd be inclined to just leave the kids with mom for this weekend. Your client had them last weekend, and I'll extend the restraints to Monday.
Okay.
Well, Your Honor, the only thing I would bring up with that is that, he was a primary caregiver up until she ran off with the kids on November 24th. And then we didn't start to get, please don't interrupt. We didn't really get this started until early December. My client was law abiding, didn't cause any trouble. So it would kind of be fair, because we're probably going to end up with 50-50 on this, or him as the primary. It'd probably be good to get the kids with dad this weekend, and he's available to do that. And it would kind of make up for some of the
Okay, stop.
shenanigans and games.
Stop.
Thanks.
I've ruled, I'm setting it over to Monday.
Thank you.
I saw the every other weekend. It's not prejudicial to anyone. I'm gonna leave the kids with mom right now for this weekend to Monday. You'll have plenty of time to get whatever you want said. You'll have extra time on Monday. So
You'll do a reissuance
I'll do a
order?
reissuance. Mr. McGee, you're here. They don't have to do service. I'll do the reissuance.
And he's here
just to
too.
Monday.
He's here.
Oh, and
His
you're
fiscal-
Mr. Jessup? You're Mr. Jessup. Okay.
Yeah, sorry,
So
but-
you guys are here. It's just to Monday. And then you'll have plenty of time to get whatever you want out in front of the court, and we won't be under a 10-minute gun.
In this
Thank you,
courtroom?
Gunner.
It will be in courtroom 3.
Okay,
I
thank
did
you.
check with
Just wanna
that.
know
So
where.
courtroom 3 at 1:30.
Thank you.
Thanks. So on that, on Jessup.
Your Honor, I would ask, I mean, being he's been all the way over, he's driven all the way over. I mean, it's 6 hours round trip because. So I think it would be fair if he has, maybe pick the kids up from school this afternoon and take them to dinner and kind of hang out a bit. I mean, I think they're off at 2:30 or 3 o'clock, because that would seem to be fair and reasonable, since he did drive all the way over here, and would that be the court consider that, please?
Can he have him for 2 hours this afternoon?
I think about like 3 to 8 would be fine.
Don't get out of school till 3:30.
3:30 to 8 would be fine with us.
Till 6. This is her weekend.
Okay. All right. You're fine with them picking them up at school until 6 is fine? Okay. After school till 6, Dad can pick them up. I think you were exchanging at the.
Well, that was out in Cleella, but if he's.
He's here, so do you need to go to the police station? Probably the best.
Sounds good. Moses Lake Police Station's fine with us, Your Honor.
Okay.
You guys live in, it's Moses, right, if I remember. So Moses Lake Police Station, so we don't run afoul. I don't want anyone getting accidentally arrested. So 3:30 to 6, you pick them up from school and then meet at the police station at 6. Okay?
Thank you.
All right.
And
Thank you.
Wait for the copy of the order, the reissuance order.
Okay. So
thank you.
That well, no, because we'll have to get one printed and then I'll print it out. I can print one out and then she might have to wait until, I don't know when we'll get it. But
Okay, I'm gonna
it'll
go
get
talk to her in the
done.
hallway for a minute.
Okay, thanks.
I said I gotta get to a mediation.
No.
Your Honor.
Yes, Mr. Gilreath?
If I may for a second, I'm covering for another attorney in the office for a hearing in Spokane at 2 o'clock. I have one matter left. I'm not sure if you wanted to call it. Or
Is it?
I know it is, and he's in the courtroom as well.
Okay. So, we can do one of two things. We've got a few cases. I have to be gone this afternoon. I have to take a kid to a dentist. And so I can set this over to Monday.
Can we do it just right now?
Well, we can do it or we can do it on Monday.
We can do it right now.
Okay, so hold on. I need to see if there's not a whole lot at issue here, but it is adequate cause. And so I want to make sure if you want some time, we can set it over to Monday. Are you available, Mr. Gilreath, on Monday?
What time would that be, Your Honor?
We could do the morning or the afternoon.
Let me look really quickly.
The afternoon, it'd be after the 1 o'clock here at 1:30,
I could do Monday morning.
Okay, can you be here Monday morning?
Why can't we do it right now?
Well, because it's almost noon. We got other cases and I'm trying to just figure out if you want me to, if I don't want to hear, if you don't want to present anything, I can just rule. But I'm assuming you want to make an argument and a presentation.
Can I be sure?
So.
I've been here since
Okay,
night.
you can wait to the end and we'll see. I mean, I just don't know. Do you want to go to Monday? Or not?
It's up to you.
Well, we can do it.
Well, we can do it right now. I'm okay with that.
Okay, we'll wait to the end. Hold on, Mr. Gilreath. We'll see if I got to see who else.
No worries, Your Honor. Thank you.
Okay, we have the 15 case. No, that's that one. And then you got 24, 298. That's the Stoyanova. So that's Mr. McGee and Wynn.
Lynn, I'm here, Your Honor.
Yes. So what do we want to do? This one, if you can do it
Your
really.
Honor, I'm okay with going to the 7th. You know,
What about Monday? We could do Monday and just get her done. 7th
yeah,
is
I would
that'd be
prefer
fine too.
the 3rd. I'm not available on the 7th. On the 3rd, is it gonna be morning or is it gonna be afternoon? Because I have a hearing in the morning already.
we could do the afternoon.
And what time in the afternoon?
Well, it's going to be after the case at 1:30 that is already, we have, I just put it at, it'll be, probably be 2 o'clock, you know, but I mean, I'm just going to say 1:30 but there's only one person in front of you. So,
Okay, so let's go ahead and set it for 1:30, assuming we'll go at 2.
okay.
And
So
is it gonna be in this courtroom, Your Honor?
It'll be in this courtroom. So Mr. McGee, since you're here on the other one, that's probably what works for you, correct?
Yeah, I want to cooperate any way I can. The court's grinding through.
So 24/3/298/13, the Stoyanova will be set over to Monday at 1:30 or as soon thereafter as can be heard. You won't be the first one. So if Mr. McGee, if you reach an agreement with the other side, I doubt you will on that case, let Ms. Wynn know that it'll go earlier. So, all right, so we'll do that one at 1:30. Then we have, oh, is that it?
No, well.
It was Shearer, Your Honor, I think, presentation.
Your Honor, may I be excused on the Stoyanova? I just want to make sure I can leave the platform.
Yeah, it's set over to 1:30. Thanks.
Thank you.
Okay, on the or on the Shearer matter, that's Mr. Anderson and Mr. McGee. We can do one of two things. You know, we can, it's on for a presentation, and Mr. Anderson, you didn't supply any proposed documents.
No, Your Honor. Yeah, I guess I'll let the court know real quick. We did supply one declaration. We don't disagree with I don't disagree necessarily with the documents presented by Mr. McGee. My client is asking that I ask the court to reconsider the matter of where the $17,000 judgment against Ms. Shearer, whether that comes off the top after the, once the house is sold, or whether the parties evenly split the proceeds and then she pays out of her share. That's just the only issue we're really bringing forth to the court today.
Okay, so you agree with the form of the order. It's just the $17,000 equalization payment?
That's correct, Your Honor.
Okay. Mr. McGee?
Briefly, I think the transcript is clear. The court said it comes off the top, but I'm certainly happy with the court to take it under advisement. And then, I did provide a transcript, I believe, of the ruling portion of the trial. I hope the court has it. But I think that's pretty clear.
And Your Honor,
off the top.
I didn't transcript.
You don't have a transcript, Your Honor? I believe I've requested one or asked the staff to get one.
Mr. McGee, you did get a transcript. It just hasn't made its way into the
Your
court.
Honor, can I just check? Let me just check really quick. I'm just make double sure I'm not misrepresenting.
And Your Honor, I don't know if Mr. McGee is still online with his.
I'm sorry.
We fully agree. That's what the court ordered. As the court will recall, this was, the court made its ruling at the end of the day. We're all quite tired, and my client is just saying that he didn't realize at the time that the way in which it works out mathematically. And so we're just asking the court to reconsider that at this time. Other than that, everything else is fine. As I said, we do understand the court said that it would come off the top if we had all been a little bit more on the ball at the end of the day. I would have made that observation to the court on behalf of my client. And that's why I said my client is just asking that the court take it under advisement and make. Your
Honor, I'm sorry, Mr. Anderson. I don't mean to be rude to you. The court rule comes off the top. I see I paid $138 for a transcript. I'm and a disc fee. I'm not sure where that is at, but I just would ask that the court enter our orders today so we can please be done. And then if Mr. Anderson wants to bring that back on reconsideration, I won't hold it against him in any personal sense. So, but we really need to get this case done, and there's been no alternative orders proposed, just pages and pages of stuff that it doesn't really disagree with the orders that I drafted. So please, can we please enter the orders today?
Well, you ordered a transcript. What I can do, and that's probably the only thing, I mean,
well, Mr. Anderson admits that the court said off the top, he just doesn't like it, or his client doesn't like it. So, we've drafted it as the court ruled, and he admits the court ruled it the way his client doesn't like it. So it's a reconsideration issue, not a relitigation issue. I'm sorry I jumped in there, but I want everybody to get lunch.
So, Mr. Anderson, if the court, if you're not, you could bring a motion to reconsider. That would be the appropriate.
Yeah, I understand, Your Honor. As I said, I had no idea the docket was going to be as full as it was. My client asked me to submit his declaration, which I did. And I guess we just need to make sure that I did see that it looks like Ms. Shear's online, that there is likely going to be a motion for contempt for her removing several items of property that the court had ordered to be split 50-50. Again, that's not before the court today, so I'm just going to leave it at that.
Well, Your Honor, let's let Mr. Anderson come back on his reconsideration and his contempt, and have one hearing as opposed to 2, 3, 4.
Okay. Well, Mr. Anderson, you haven't supplied additional documents. You indicate that that's how the court ruled. I will sign these documents because it is on for presentation, and you don't object to you don't disagree that's what the court ordered. Now, you can definitely bring a motion to reconsider, and Mr. McGee, you're obviously on notice of that. So
sure. Like I said, I wouldn't hold it against him.
And we'll go from there. And Mr. McGee, if you did get the transcript, you can file it. That's always helpful. But
yes, I will provide the transcript to Mr. Anderson and file it with the court. I'm sorry, I just don't know where that because I see that we paid for that just the other day, so it might just be with a transcriptionist.
Okay.
Your Honor, Mr. McGee did provide me with the transcript.
Okay.
I'm not saying I didn't receive it. I received it. That's why I said that's what the court said. I was again just stating that my client wished the court to reconsider. We will file a motion for reconsideration.
Yeah, if you can't get a motion that way, so I've signed the orders. The parties are divorced. Get a motion in, and we'll see where we go.
Okay. Thank you very much, Your Honor. And thanks for letting me know the transcript didn't get there. I'll try to figure out what's going on. So thank you.
Yeah, just got to get it filed with the court. All right. Okay. So then, is that everything except for the Mr. Gilreath and Mr. Fernandez's matter?
Right. Yeah.
Okay. Other than the Jimenez and Garcia matter, Jimenez Fernandez and the Garcia matter, anyone have a matter that they think was on the court that wasn't called? No? Oh. Mr. Gilreath, as far as the 15-3-177-9 Jimenez Garcia, what are the parties? Do you want to go to Monday? So you have a little time, or do you want to do it? I'm giving you the option. Otherwise, it's going to have to be quick because we're, into the noon hour.
We can do it right now,
Okay.
if that's okay with you.
That's fine with me, Your Honor.
Okay, then I just want it known for the record. I wanted to make sure there's an alternate time available where you'd have more time. But if you're good, then go ahead. Okay, it's on for two things: presentation of the contempt order, and then the adequate cause by the dad. The easy one's the contempt. It's just on for presentation. I believe. Do you believe that the proposed order doesn't reflect what the court ruled?
I disagree with that.
If I may,
Huh?
I didn't rule.
I don't know who rule it. So I'm asking to see my son. That's it.
Your Honor.
Yeah.
If I may, I think this may be best set for Monday only because he has requested an interpreter before and
I'm okay
there
right
may-
now. Do it.
I understand. I just wanted to, I drafted the proposed order that reflect your oral ruling last week. Thank you.
Okay. You don't want to go to Monday.
We can do it right now if we
All
can.
right. On the contempt, you didn't supply a alternate order for the contempt on the child support.
No, I didn't.
Okay. The order does, the proposed order by Mr. Gilreath does reflect the court's ruling. I found you in contempt for not paying child support. I did only order the $1,000 in fees, and that is accurately reflected in here. That I think the original proposed order was $3,000 in fees. I ordered $1,000. So I'm going to sign the contempt order. It does find you in contempt as I orally ruled. You can purge the contempt by starting to pay the child support. And I think you indicated in your materials you want to pay the child support. So I am signing that. There's no further reviews, just pay the support. I will put the contempt can be purged if you start paying support. So I've signed that. So that's the simple one. Now, as to the adequate cause order, sir, I'll hear from you.
Oh, I'm just gonna say that I'm just gonna see my son since I'm gonna pay child support. So I have all the right as a father to see my son.
Okay.
That's it.
Mr. Gilreath?
Thank you, Your Honor. I did receive, not receive, but I pulled up on Laserfish here. It seems that Mr. Fernandez has provided a reply declaration. I have read it. My client's position is that there has been no substantial change of circumstances to find adequate cause to change the parenting plan. The child support and the parenting plan were entered on final orders in 2017. We put on the other things, the courts reviewed it. There are serious concerns for my client's son having any time here with Mr. Fernandez. He's admitted on the record that he is currently not a U.S. citizen. His DACA expired 10 years ago in 2015. That continued into when the final divorce orders were entered in 2017. In her declaration, she put on evidence that he's brandishing firearms. This is, I'm pretty sure, a felony under RSW 941171. Our position is that there should be no finding of adequate cause here, as there has been no substantial change. I noticed in Mr. Fernandez's petition, he actually did not check a box for the minor change. So I just wanted to point that out to the court. And just to supplement, he's never paid child support. There was a domestic violence protection order against him from my client. There are clearly concerns of my client with Mr. Fernandez having any increased time with the child. And then I will reserve for questions. Thank you.
So we're here on adequate cause for a parenting plan. Sir, you filed a modification. So the current parenting plan does not supply any time for the dad. It was entered back in 2017 by Judge Reese. The minutes of that trial indicate that you didn't appear and that the father, that the judge just said there'd be no time and that the father would have to come back to court to request time. So now, sir, you've done that. Yes. However, what you've done is you filed a petition to modify and you marked a minor mod. You didn't indicate there's various bases for a minor modification. You didn't indicate which one you're moving under. Additionally, your parenting plan that you supplied, it does not, your proposed plan, it's every other weekend. that basically goes from 0 days to 50 days, which is more than the 25 days that you can, is a safe harbor. There's reasons you can do it. You can request more than 25 days, but you haven't marked which one. I would point out, it does appear that the father at the time in 2017 lived down in Mexico, and now he's moved back to Moses Lake. Again, you don't address any of that and the basis for your minor modification. Also, you haven't addressed the limiting factors. Judge Reese found limiting factors of abandonment and neglect. The only thing you said in your materials was that you kept your distance from the mom.
Yeah.
You kept your distance to give her your space,
Well, I didn't say that.
Well, that's what you put in your declaration. You
Well,
kept your distance to
Because
give
I
her
have a
space.
restraining order, sir. So,
But what I'm saying is, so long story short, I am going to deny.
you're
the-
gonna deny it?
Hold on. Listen. I'm going to deny without prejudice your request right now because, sir, you didn't properly fill out the petition and identify what I just talked about. What basis of the minor modification are you going under? You haven't supplied a parenting plan that is compliant with, the basis you're moving under, and you haven't addressed the limiting factors that were found, it's in the current plan of abandonment and neglect. I acknowledge that the minutes and the parenting plan, it indicates you can come back to court and ask for things, but you can't come back and just say, I want every other weekend. You have to address those concerns, and you have to supply a plan that the mother can respond to that is appropriate, that's compliant with what you've asked for. Typically, in these types of situations, it starts out with, it's supervised and then monitored, and it starts out a few hours at a time, not just immediately to every other weekend. You've been out of this child's life, and there are those limiting factors. Now, they're abandonment and neglect, Mr. Gilreath. It's not drug use or mental health or something, that there'd have to be an evaluation done. But again, sir, you're going to have to address what you're asking for. And the mom is correct, you haven't properly got it before the court and addressed those issues that she's raised, that, you've been out of this child's life for many years and you can't just come in and have every other weekend. It has to be a gradual plan. Address the abandonment. Give them something that they can respond to, and whether the court would grant it at that time, we'll have a hearing on. But so I'm denying it without prejudice because you're not in compliance with your request. You haven't shown what basis you're under and filed your request that fits, that's compliant. You can't ask for a minor mod and ask to have full custody. You didn't do that here, but that's one example, and minor mod is limited. So look at your petition and see that. And then, like I said, you got to address the abandonment and neglect. Usually it's some sort of a graduated plan, and that way the mom can respond to it. So it is denied right now.
Baby steps.
And you need to see what so. All right. So
Your Honor.
In order on adequate cause, denying it, and it's without prejudice, Mr. Gilreath, because procedurally hasn't shown a proper basis. And
I understand, Your Honor. If I may add one more thing.
Sure.
The final parenting plan from 2017 stipulated that Mr. Fernandez is to have no contact with the child absent a court order. Since November, Mr. Fernandez has been trying to make contact with the child by following him home from church following him to the grocery store after church and various places like that. And it is terrifying the child as the 7-8 year gap here. So if we could just remind that that's how we're to proceed. He's not barred from petitioning the court here. He shouldn't be following the child home or following to places out in public.
So, okay. I don't know, and you can maybe talk to Mr. Gilreath about, I don't know if Mr. Gilreath's client would object to some phone contact or something by mail, some letters back and forth initially, kind of like the baby steps. I don't know. It's not properly before the court, but you guys can maybe talk if there's some ability to do something like that. But sir, yeah, you don't be, following, harassing or anything like that. I'm not saying you're doing that. I'm just saying, so, and if you need to, file but right now.
Well, first of all, I'm not following my son or my ex-wife. I can go to any store I want or church or whatever place that I need to be. So I don't know what
We're
is.
not before the court on that. I'm just saying, and maybe you guys can talk about some form of, letters or phone, but I'm not ordering that.
Yeah.
So, all right.
Well,
I've denied adequate cause without prejudice. I wrote in on the order without prejudice, and I've signed the contempt hearing order, for the child support, and then that's what we're doing today. And so, like I said, you just have to refile with
yeah, I'll do that.
appropriate steps. You can seek the advice of an attorney if you want. That can help. So I can't give you legal advice, but I can tell you why I ruled the way I did. All right. That's it. Thanks.
Thank you, Your Honor. Have a good weekend.
Thanks. I'll recall the guardianship, and I think that's all the cases, right? Okay, we'll recall quickly the guardianship of Trevor Gollihar, 20-4, 112-13, calling it for the second time at the end of the docket. Is anyone present on this matter? Stephen Gollihar? Nope. All right. Matter is set out to, I think it's March 7th, and I'll send a letter. So I need this one back, and I'll do a letter. All right. Anyone have a matter that they think's on the docket and wasn't called? No? All right. We'll be in recess. Everyone have a good weekend.